professor of the University of the Bahamas, the lawyer, the educator, the father, and the nationalist. We are prepared to receive you, sir. Will you all give him a round of applause? You know your little indicator at the back. At
Yeah,
the
I've seen the hand claps. So they have to make me a host, or can I just go ahead from this that I have?
You are a host, sir. You could share your screen.
Can you see that?
Very much so, sir.
Okay. Good morning, everybody, and let me first apologize for the snafu, so to speak. But I tried getting on very early, as I would normally try to be very punctual, and I was locked out. So thankfully, they were able to access me through a different medium, different platform. But here am I. So I've sent you quite a bit of material for you to browse. And we will try to get through as much of this as possible in the time we have remaining. So here's what we're doing today, the two modules. One is the legal foundation of public administration, the relationship between the Constitution and public administration or public law. Sometimes, or most of the times, public administration or public law is used interchangeably with administrative law, and you will understand as we go along why that is the case. So, the objectives for today then would be to demonstrate an understanding of the nature and characteristics of the Constitution, and critically important for this exercise is for us to get a very basic understanding of the model of government that we have inherited, the model of government that we use in the Bahamas, which is called the Westminster system of government. And it is what we operate under. And part of the problem we have in the country is that not many people really have an appreciation or an understanding of what this Westminster system entails. So we're going to try and go through a little bit of that today to make sure that you can understand, you as prospective FASs and deputy permanent secretaries and so on, and the persons beneath you also have a better grasp on what this Westminster system is all about. It's a system that has been handed down to all of the former colonies of the United Kingdom. So it doesn't matter which country you go to, we've all inherited the same system, which we still operate today, save and except for a few of the Caribbean countries now that are moving towards a republic form of parliamentary government. And of course, Canada, Australia, and some of the other larger countries have since shared the Westminster system in favor of a different kind of political system, constitution. Secondly, explain and define the legal basis of administrative and public law. And then, of course, thirdly, demonstrate an understanding of the relationship between the Constitution and public administration and the role of the judiciary. The judiciary is critically important in this regard because when we speak to the independence of the judiciary, when we speak about the rule of law, which the judiciary has to they are the gatekeepers of, then we'll understand why that is very important in terms of public administration, especially when we speak later down on the issue of delegated authority, because we will soon see that there are a level of delegated authority that comes down from the minister to the permanent secretaries, to the deputies and so on, which would be delegated authorities. And as a result, there are only certain authorities that you would be able to exercise. Anything over and above that, the permanent secretary and those above would be the persons who are able to exercise those delegated authorities and critically evaluate the Constitution in a more, what am I saying, why the Constitution is more important for stability of good governance. So those are, hopefully we will get through those in the next couple of hours. You can stop me as we go along. I just don't want this to be a dialogue. I would like to have participation, if you will. So the preamble to our Constitution then, it says that we, the inheritors of and successors to this family of islands, believing in the fundamental rights and freedoms of the individual, do hereby proclaim in solemn praise the establishment of a free and democratic sovereign nation. Those are very choice words, free and democratic sovereign nation. And to go with that, it says, the Constitution then is the supreme law of the Commonwealth of Bahamas. All of the other laws that are created in Parliament, which are called statute laws and or statutory instruments, are subordinate or secondary to the Constitution. We will see that any law that is promulgated that is not in sync with the Constitution, as you see in my third frame here, if any other law is inconsistent with this Constitution shall prevail, and all other laws would be regarded as inconsistent or be void or ultra vires or void ab initio. Those are Latin words that we understand the meaning of in terms of law. So that's going to be critically important as we go along. Also, it says that, and whereas the people of the family of islands recognize that the preservation of their freedom will be guaranteed by the national commitment of self-discipline, industry, loyalty, unity, and an abiding respect for Christian values, and what I highlighted, the rule of law. We will go through and get a thorough understanding of what this means, the rule of law means to good governance in a democratic state. So there we go. So very quickly then, can you take just a minute and write down what you might think is a definition for the Constitution? Just very quickly. Just one definition of what you might consider to be what the Constitution means. Anyone who might have already done that, you can put your hand up and you can speak. I think everybody's got their microphone open, I believe, eh? Is that correct, Elma?
Yes.
Right. So anyone want to give it a go?
The Supreme Court of the Supreme Law of the land, which guarantees the rights for all.
Okay, the Supreme Law of the land, which guarantees the right for all. What else?
Supreme authority governing the land.
The supreme authority governing the land, yeah.
Laws that govern a country and its people.
The laws that govern the country and its people, for sure.
The highest law of the land.
I didn't hear that.
The highest law in the land.
It is the highest law of the land. Being the highest law is called the supreme law, so no other law can supersede the laws in the Constitution. None. So every other law that is written and done in Parliament, all the bills that go to Parliament to become law, must be in sync with the Constitution. And so if there are any laws that are outside the framework of the Constitution, the courts, now here's what is important. While the judges do not make law, that's not their job. Their job is to interpret the law. Parliament makes the laws. So even though a judge may find something that is wrong with the law, his job is not to fix it in that way. His job is merely to interpret the will of Parliament. So he will go back into and look at the methods used by judges in the courts to interpret the will of Parliament, rather than striking down something that the law that they might consider to be ultra vires. So if you think I'm going too fast, you can slow me down. Okay? So let's move on. And it says that here we understand the relationship between constitutional and administrative law, which I've indicated before, the workings of the Westminster system. And I want you all to just, those of you may know a little something already about the Westminster system. We'll talk about that very briefly. Okay, so here is the Westminster system coming up for you. On the passing of the British Empire, the British left in the wake of its disintegration some 50 specific legacies, that is all those countries around the world that were once colonies, and more so for us in the Caribbean. The legacy was to every Commonwealth state a written constitution. Now, that is peculiar because Britain itself does not have, quote unquote, a written constitution. Britain itself is regarded as a country, the only country in the world with an unwritten constitution. Now, that is also not correct because the British Constitution is found in several different documents. And that is why it is called, it is not found in one particular document. It is found in several different documents. That is why it is regarded in the literature as an unwritten constitution. But you will understand, in passing off the colonies to independence and self-government, what they've done for them was to give them something that they didn't have, which would have been a written constitution. So here is what we have inherited under the Westminster system, which governs the way we think, we behave, the way we manage our affairs administratively, because we're going to find the Constitution as the supreme law, we're going to find the statute laws which are done in Parliament, and we're going to find a lot of conventions. Listen to that word, conventions that have been inherited from the British, which helps to guide the process of administration and parliamentary procedures. And then, of course, we have the common law, which also we've inherited from the United Kingdom and ourselves many years back. So we have then the written constitution, which we've gotten from Britain, and at least one chamber, what it says in terms of what the Westminster system says, it is a written constitution, first of all. At least one chamber in the legislature is democratically elected by an adult citizen by secret ballot. This is what they've said when they set up the Westminster system for the regions. From one or more political parties, so you've got a secret ballot, meaning the election that is taking place. You've got more than one political party. The executive power will rest with the crown meaning the Queen of England or the King of England, whoever might be the titular head of the United Kingdom or that state, the head of state. But it was to be largely exercised by a cabinet of ministers, a servant of the crown. This cabinet of ministers, as we will see a little later on, is also regarded as responsible government. So when we got our first written constitution in 1964, you would have heard everybody talk about responsible government or responsible cabinet government. That's the issue there that came down to us in that regard. And so that's how we manage our system. the cabinet really is the government of the Bahamas. It reports to Parliament. So, and the Prime Minister happens to be the head of the cabinet. So we'll understand how that works. So, and it is to be chosen from the party or the parties that have the support of the majority in the Parliament, or the people who were elected and answerable to the House of Assembly. So these are some of the features of what regarded as the Westminster model of government. In our Constitution, you'll also see that the Westminster system also does recognize the opposition and the leader of the opposition, and it is called Her Majesty's Loyal Opposition. Okay? Anybody want to chime in on that? It is called Her Majesty's Loyal Opposition. That is part of the Westminster system we've inherited. Fifthly, there is this recognition, as I indicated, of the opposition. And number 6, a set of constitutional conventions, fully working model of the Westminster system. Conventions are not law, but they carry the force of law because there have been matters that the countries dealt with and believed there were mores that politicians observed and carried on long before the written constitution. That is why they're considered to be constitutional conventions, and that we obey them as the same way we obey laws. And we will see how some of these conventions, once they've been transgressed, even though there is no law to say what should happen, the convention dictates what should happen. Now, fortunately for us also, that since we got a written constitution, especially in our second constitution, which is the Independence Constitution, many of the conventions, and we'll see some of those in a little while, many of the conventions have been codified. Codified meaning some of them have been included in the Constitution, so they're no longer conventions because they become part of the constitutional law. And some of them you will find in what is called the Cabinet Manual of Procedures. I'm sure you all must have seen that document already. If not, you will see it in a couple of the topics that are going to be discussed later on in this week. The Cabinet of Manual Procedures spells out in every Commonwealth country, they have one that is called the Cabinet Manual of Procedures. This came into force about 2011. Even Britain was able to put one together and is now beginning to codify for them much of their constitutional conventions. So the Cabinet Manual of Procedures sets out in detail the workings of the cabinet, the workings of government ministries, the roles and duties and responsibilities of permanent secretaries and those persons below them, and what should happen if something should happen. The collective responsibilities for ministers, the individual for cabinet, the individual responsibilities for ministers. So that's what's important in there. Any discussion on that so far? Very quickly.
Mr. Sumner.
Uh-huh.
Hi, Lucretia Dean Roll here. One question back to Her Majesty's Royal Opposition.
Uh-huh.
Loyal opposition. Yeah. I want to know, okay, we have official opposition, right? We call it official. Uh-huh. But we have maybe several other parties that would try, or independent, try to win an election or go to the government, the government administration. And I wanted to know, why is it then that the official opposition that we have, why they're recognized as just one and not the other persons who would have run independent?
Well, first of all, to be an official opposition, you will have to have a seat in Parliament.
Yes.
If you do not have a seat in Parliament, you can be on the fringe. You may be regarded as an opposition, but not as the official opposition.
Okay.
The Constitution is very clear on the role of the official opposition. That is why you'd see the Prime Minister, though he is the head of government, the Governor General is the head of state, but the Prime Minister is the head of government. And even the Prime Minister under our Constitution cannot do a lot of things unless he consults with the leader of the opposition. Now, consultation has a different connotation. It doesn't mean that you have to agree. All it says is that you must consult. And there would be a lot of areas in administrative or public law where the Constitution dictates that the Prime Minister must consult with the leader of the opposition on such things like the Governor General, appointment of the Governor General, the appointment of the Chief Justice, the appointment of any number of the Commissioner of Police, sorry?
Senators.
Senators are only to the extent that they are looking at the independent senators. The Chief Justice and so on, those are the responsibility where he must consult with the leader of the opposition. Now, the question that you asked earlier was whether or not, if there are several smaller parties in Parliament, they will still not necessarily be the official opposition. The official opposition will be the party with the greatest number of persons.
Okay.
Okay?
Okay.
Good.
Thank you.
So,
Question, Mr. Sumner. In the event that no one wins a seat in the opposition, does the Crown then name an opposition?
the Crown will appoint an opposition.
Okay.
Yeah, because the Constitution says you must have an opposition. So a government can win 38 seats, as you've seen down in the Caribbean. On several occasions in the Caribbean, Barbados, for example, I think just now, and one or two other Caribbean countries, and so the Constitution says that you have to appoint an opposition.
And
I think what they've done was to appoint people from the religious community and so on as the opposition, as opposed to anybody from one of the sitting opposition parties. But go ahead.
So what you're saying is that the Crown can appoint persons that were not democratically elected to serve as opposition?
Well, if you have not been elected, right, the Crown will then appoint an opposition. Now, that is not to say that they may not go and look at somebody who was defeated, which would be the right thing to do. The point I'm making is that they will go ahead and appoint an opposition.
But
okay?
I'm not clear on that, because if you go through the process of saying you're gonna have 39 seats, you go through the legal process, Boundaries Commission outline 39 seats, 39 persons, the winning party, all of their persons were elected, 39. I question now how the Crown can interpret the Constitution and or what other law to say now I am going to appoint more than 39 people to be in the House of Representatives at a cost to the taxpayers.
No. They may not necessarily be in the House of Assembly. They will simply be an opposition now. I'm not necessarily the high constitutional scholar in that regard, but if we look at what is happening in Barbados now, that will give us some indication as to how the Crown behaves in that regard. If we look at what has happened in one or two of the other Caribbean countries, where the opposition lost all of the seats.
Turks and Caicos.
And the government they went ahead and they appoint an opposition.
Shouldn't the opposition be appointed from?
I could see the Crown appointing. persons from within the 39 that may not be may not be cabinet ministers or may not be appointed cabinet ministers to serve as the official.
That is very possible. That is very possible too. But what you would have done, was to break up a governing party into an opposition, and right. But that may be a formula. Now I'm not the constitutional scholar to be able to say precisely, but we could be guided by what has happened in the Turks and Caicos, what has happened in Barbados. That would be the precedent for us to look at.
Yeah.
And I think there was another country down in the Caribbean that elected all persons to one party as the governing party. Okay?
Okay.
And the idea is whether or not are they legally, they're right. They're not
allows you to do it.
Exactly.
The Constitution allows you to do it.
Allow me to do it.
How it is done would be a matter for the constitutional scholars to argue before the courts.
But it's law. It can be done. Constitution allows it to happen.
Exactly.
Yeah.
Mr. Sumner, I have a question.
Go ahead, sir.
What would happen in a case where you have three parties and two of them get equal seats, but you do have one that got the majority of them? So in an instance like that, the opposition would be who? Between, again, choose from the two equal parties?
If you have two opposition having the same numbers, then I don't know, maybe the Constitution might look at a co-equal in terms of opposition.
Okay.
Because it is not very clear as to how they will appoint a leader of the opposition as recognized as the official opposition in that regard.
Mr. Sumner, Monique Molly here. What happens in the case if the leader of the winning party does not win his or her seat? Does the Crown appoint the Prime Minister?
No. What will happen is the party will then choose a new leader who is in Parliament. That person will then be sworn in as the Prime Minister, and the person who was previously the leader of the party will remain the leader of the party on the outside. But for the purpose of being the Prime Minister, that person will be elected by the persons in Parliament, and they would so advise the Governor General of their support for that one person, because in the Westminster system, in order to be a Prime Minister, you must have a seat in Parliament.
Mr. Sumner, I believe we came, Drexel on Bristol here. I said Drexel on Bristol speaking.
Okay.
I believe we came very close to that issue with the opposition prior to the 2017 election, when we had this system where Mrs. Loretta Butler Turner was actually the leader of the official opposition, while Dr. Hubert Minnis was the leader of the party.
Exactly right. Not that we come very close. It was what it was. That's a classic example of where you had the opposition. Dr. Minnis was the leader of the opposition in Parliament,
yes,
because at that time he enjoyed the support of all of his colleagues.
Yes.
And then there was this problem where the parliamentary colleagues withdrew their support from him in favor of Ms. Loretta Butler Turner. Loretta Butler Turner, the letter that was sent to the Governor General saying that we no longer had any confidence and support in Hubert Minnis as the leader of the opposition in Parliament, they didn't say as the leader of the party, the leader of the opposition in Parliament. And so the Governor General had to act constitutionally to now recognize Loretta Butler Turner as the official opposition leader in Parliament. Hubert Minnis remained the leader of the opposition outside of Parliament. And there you had that kind of quote unquote conduction. Okay? So that's a classic example.
Mr. Sumner, Marsha Jackson speaking. And I think we also had that situation earlier before that when I think Mr. Tommy Turnquist was leader of the opposition.
And Alvin Smith was
He was
appointed,
leader of the
Alvin
party.
Smith was appointed the
And
leader
Alvin
of the
Smith was
party in
leader of
Parliament.
the opposition.
And it happened long before Alvin Smith. It happened during the period
During
of Kendall Isaacs.
Isaacs, yes.
Harold Times was appointed the leader of the opposition in Parliament.
In Parliament.
So we've had a long history of that happening in our Constitution. And that tells you how important the Constitution is and how it forms the legal foundation of how we behave and how we act. And so once you're true to the Constitution, I think everything will go exceptionally well. So
one more question.
Uh-huh.
In the three-party system, the two parties with least vote, can they join and form the government?
Yeah, you can have a coalition government.
If they are
coalition.
You can have a coalition government, yes.
Okay.
In fact, the 1968 government was
coalition.
Yeah, that's a normal process.
Yeah, but that was an even split.
No,
I'm talking
No,
about.
it was not.
It wasn't?
No, you're the PLP receiving 18 seats.
And two oppositions and two
and
independent.
You had one independent and one labor. So we never had majority government until 1969, because the 1968 government was a coalition government. But a lot of people don't seem to understand that. Under our system of government, it was regarded as a coalition government, where you had Randall Fox representing Labor, and you had Brennan as an independent. Any other question there?
Did they,
let me ask.
Did they join the Progressive Liberal Party, or did they?
None of them did. None of them did.
They joined the party in the House.
But they remain independent. Okay?
So they
just joined to form the government.
So they caucused with them.
They caucused with them.
Okay.
Okay? They just saw their support formally behind them.
Oh, good. Okay, good day. I'm just getting in because of my up and down, but I don't know if you answered this already. If the leading party gets about, say, 15 votes, and the other two parties get in with 111, say 113, those 11 and 13, if the 15 is the highest, and that's the government, I guess, at that point, can those two parties combine and overthrow the government?
Of course, because once you have two opposition with the seats greater than what the government has,
you become the government.
Once they combine, they hold the majority. And once they hold the majority, the Governor General will be duty bound to appoint the person who is considered to be in control of the two smaller minority parties in Parliament.
But as you
the problem with that is, and you've seen this in many of the Westminster models, where you have coalition governments, the sides fall out and you have to go back to a fresh elections. Because it is one of the vicissitude of coalition. If one side disagrees with what the other side does, then they can withdraw their support. It means either the other party with the greater number now will form the government, or they have to go back for fresh elections for a mandate from the public. Okay? So the Constitution also speaks to the mode of elections, which is very important. The duration of Parliament, which is also very important when we talk about how important that is. And we'll see this again when we talk about the stability of the Constitution. It tells you how people are to be elected, how old they should be, what would be the criteria that they must meet in order to be a candidate in the election. The duration of Parliament, 5 years, and so on, or by what other such bodies may they be called, whatever that might be. So that's part of why you see the Constitution being supreme, really tells you what ought to happen in terms of a government or governance. And so going on with the definition, then it's also a document having a special legal status, which sets out the framework and the principal functions and organs of government. Now, what's that word? The principal functions of the organs of government. We will look at what those organs of government are in about 2 frames from now within the state, and declares the principles or rules by which those organs must operate. Now, a lot of times, because we're so close to the United States and we can click and watch the proceedings in the United States all along, sometimes we get confused with the federal system in the United States and believe that we could import that federal system in the Bahamas. You have a federal congressional system in the United States. We have a parliamentary democracy in the Bahamas. They're 2 different creatures, absolutely 2 different creatures. Okay, so you see also down here some of the definitions. I'll leave that for you because you can have these handouts, I believe, later on. A constitution is a thing antecedent to the government. Again, as I indicated to you, we didn't have to do very much for our constitution. It was on the shelf. All we had to do was fill it in. Now, I don't want to insult the framers of the Constitution, but if you read the Constitution of every Caribbean island,
basically
they all say the exact same thing.
Yeah.
Even Canada.
Only the name change.
Yeah. Even Canada.
Okay.
Mr. Sumner.
Go ahead.
Maxine Duncombe. I just have a query. I think in one of the handouts that you submitted, you spoke about the monarchical style of government, which has to do with the Governor General representing the Queen.
Right.
But now you're referring to the fact that we have a democratic parliamentary style of government.
It says, hang on.
So
hang on. What it says,
I'm just trying to marry those 2 in my mind, because in your handout you're saying that a style of government is monarchical style, and then
yes, it is
democratic.
It doesn't subtract from it being democratic. It simply just says, it simply just says that your head of state is the monarch, is the queen, is the crown. And all of the Westminster system put that in the Constitution to observe the Queen as head of state.
Mr. Sumner? Hi, this is Lisa Fitzgerald here. I'm just wondering, would you consider us now wanting to have debates, like a debate between the Prime Minister and the leader of the opposition? Would you consider that an example of us trying to import the federal system? Because I know they do that sort of thing in the States. Do you see us kind of leaning more towards that system?
Now, here's what happened. Up until the last 2 elections in the United Kingdom, that's the way it used to still remain. There was no debate. In the United Kingdom, in the last 2 elections, they borrowed the American system where the leader of the opposition and the Prime Minister, they went head to head in several debates. So even England borrowed that process. And to answer your question, yes, we would be borrowing that American federal system in our system, and there's nothing wrong with that aspect because it does not change the Constitution. What it simply does is broaden this perspective of the opposition and the governing party to be able to advance their manifesto to the public, because you would understand under the system that we have, the manifesto is a contract. More often often than not, people are elected, governments are elected on the basis of what they say or promise that they will do if they're elected. So it's a contract between the citizenry and the political parties. And so the debate then is merely to help them to clarify for the public what their manifestos are, or their covenants are, or whatever they might want to choose to call it.
Mr.
Thank
Sumner.
you.
Mr. Sumner. In America, the presidential debates are a custom that is not articulated in law.
No, and I just said it is not necessarily written into their constitution. It is custom. It is almost like a convention in the British system. So it has been historical, and the point I'm making is that it is now being borrowed by other constitutional democracies as a way of making sure that the public can get a good look, a good glimpse at prospective prime ministers and prospective governments and what it is they plan to do, and they can defend it, what they're doing. So the public is better off by hearing these constitutional debates, so to speak. I wouldn't call them constitutional debate, but these party debates. Okay? So having said that, then, the Westminster system, again, if we look at it, in terms of the classification of constitutions, I've just indicated to you that ours is written, the United Kingdom is unwritten, and also in terms of classifications, you have constitutions that are rigid and constitutions that are flexible. The United States is one of those constitutions that are very flexible. The constitution that we have inherited is pretty rigid, and it is rigid simply because there are what we regard as some saving clauses in our constitution. There are other clauses which are called, anybody could know what they are? Entrenched provisions.
Yes.
Entrenched provisions, and specially entrenched provisions. Now, they put those in there made to make sure that political parties that form the government cannot on their own change certain provisions that they do not like. That in order to change certain parts of the Constitution, you have to have 2/3 majority in the House of Assembly, 2/3 in the Parliament, in the Senate, and then you have to go to by way of a referendum to the public.
Yeah.
So you get 3 bites of the apple before you can make a constitutional change. That's what is regarded as rigid constitution. Now, there is something to be said about rigid and flexibility. Go ahead.
Mr. Sumner, could you clarify at least or give one example of the entrenched position that political parties are unable to overturn?
Citizenship is one. And you remember the issue of women being able to pass on citizenship to their children. That's a classic example of the rigidity. And we failed 2 times around for different reasons. But the fact is, in as much as both sides wanted to make the change because of the nature of the politics involved, women voted against themselves on 2 different occasions. And so you are unable to, if you are married, unable to pass citizenship on to a child that you give birth to in the Bahamas or outside of the Bahamas. Okay? So that's a classic example. Did that help you?
Yes, thank you very much.
The other one, as we know, that they coined very astutely, the referendum on the gambling casinos and so on, eh? So, the Constitution then can be classified as either written or unwritten. Ours is written, rigid or flexible, supreme or subordinate, Ours is the Supreme Constitution, as I indicated to you some time ago. The subordinate constitution would be where we've got other smaller states or territories that they have equal right or equal say, so to speak, in terms of constitutions. And then, of course, you have the federal or unitary. For the most part, the federal state would be in the American. Australia now has a federal government. Some areas in the Far East have already changed to a federal state. Ours is still unitary because we've got one central government. We're beginning to divest a little bit by the formation of local government, but not to the extent that it would make any meaningful difference at this stage. Very important is this word coming up here, separated powers and fused powers. Now, for the most part, you're going to see in our Constitution, we talk about separated powers. And then, of course, fused powers. Fused powers meaning that all the power is concentrated in the central government, as opposed to separated powers where you have the Congress, you have the House of Representatives, you got the president, and all of those are segregated duties and responsibilities. It's not necessarily the same in our case, but I'll show you in a little while why that is perhaps not the case. And then, of course, you've got the Republican form as a classified. Republican used to mean United States federal system, and then for us, we had the monarchical kind of constitution, which recognized the queen as the head of state, the monarch as the head of state. And so you would see in our constitution, everything that we do is done in the name of the crown. That's why you see even on the Governor General's vehicle, you see an emblem of the crown on the license plate. Anybody ever notice that? Yes. That's the reason why. Yes. Because we are a monarchical form of government with the Governor General representing the Queen as head of state of the Bahamas, and the crown happens to be straddling all of the organs of government. Straddle Parliament, they straddle the judiciary, and they straddle the executive. Okay, any questions on that? Come on. No?
No, Mr. Sumner, I have a question. Listening to you and especially concerning the rigidity of our constitution, do you think it actually hinders reform? You know, because we're changing, we're always changing the country, the demographics, ideology. Do you think the Constitution, because of its rigidity, actually hinders reform?
Sometimes it does, right? Depending, but it was put in there, and I'm going to get to something in a little while, but you'll understand why that was put in there in some instances. But it is to protect the citizenry from a government that may come to power, that may want to change the Constitution at their own whim and fancy against the will of the people.
Mr. Sumner, Mr. Sumner, this is Charlene Bain. I mean, this is so enlightening. And my thing is, and when I read the Constitution previously, and the one that was done prior to independence and after independence, it seems as though there was some, I don't know, deliberate decision by the British to have the compartments or the components of the Constitution remain, no matter the fact that we got independence. My concern was if we as a people in the Caribbean is seeking to be independent, why did we hold on to this? What is some of the factors that would cause us to hold on to that initial concept of the Constitution? Over.
Anyone could recall which Caribbean state did not accept the Westminster system?
Barbados.
Barbados is now changing theirs.
Haiti.
Grenada?
Trinidad.
Jamaica?
No, yes, Trinidad have already changed theirs to a federal form of parliamentary system. Barbados is changing theirs in 2021, August or November of this year. We had a constitutional commission, and unfortunately, if you've seen in the handouts I sent you, we decided not to trouble ours.
Not the trip, yeah.
On two occasions, we chose not to change it.
We decided not to change. We want to keep the Queen forever.
But Mr. Sumner, Kenyon, I'm here. Question. Your last comment regarding the monarchical side, the monarchy, straddling the structures of government. But how influential in the daily function or governance of government is the monarchy? I mean,
Well, let me go to one of your convention. Let me show you how important it is. One of the convention of the Westminster model says, and it is already written into our constitution, a bill that goes before Parliament. Everybody would remember the 6 stages of a bill going through Parliament to become law, right?
Yes.
Anybody can recall the 6 stages or so on? No? Oh, if I could have gone through it, but there are 6 stages: the first reading, second reading, third reading, committee stage. You remember those? You don't watch Parliament well enough, eh?
Yeah.
All right, so those are the stages. Once it is passed in the House of Assembly, under the Constitution, it goes from there to the Senate. It goes through the same process of being debated in the Senate. Once the Senate approves it, it comes back to the House of Assembly, and it goes from the House of Assembly, it goes then to the Governor General. There is a word that you need to understand. In the Constitution, it says the royal assent or the assent of the Governor General. So it doesn't matter whether it was approved in the House of Assembly or does, and when it was approved in the Senate, it does not become law until the Governor General signs it into law.
Okay, so the.
You see what I'm saying?
Yes, so the.
So that is what is called. That is what is called in the law the assent of the Governor, of the Governor General. The assent means that it is now law. The Crown has now signed it into law.
Okay.
And then after it has been signed into law, the minister responsible for that particular statute will then indicate what would be the commencement date for that to become operational. You follow what I'm saying? That's just one of several conventions. Now, the Governor General can withhold his assent for a while, but it would be foolish for him to do that, right, or how to do that. Because the head of the government is the Prime Minister. Under the system of government we have, it is not uncommon if we want to remove the Governor General, because the Governor General, though representing the Crown, serve at the pleasure of the governing party.
Yes. So that where the other question comes in, is there truly a separation of powers? I said that's where the other question comes in. That's where the other question comes in, whether there is truly a separation of government, since the Prime Minister appoints,
exactly
appoints the Governor General, and the legislation, and so it's really, is there a separation?
You're getting a little ahead of me.
Okay.
You're getting a little ahead of me.
I'll wait.
Yeah, that's fine.
So, Mr. Sumner, is that why when you look at a lot of these laws, I noticed at the beginning of the laws, you would see that it ascend, and then they would have the date.
Exactly.
Exactly. And then when it came into effect.
Now, also you would know, and those of you who are moving up the ranks of becoming First Assistant Secretary, Deputy Permanent Secretary, and even on to Permanent Secretary, that is why you have the office of the Attorney General, because even when a bill has become law and has been assented and takes effect, you have to watch and see whether the bill in its entirety has come into force or whether certain provisions have not come into force and have been postponed for some future dates. Because most of the times, or some of the times, a bill may come into force, only portions of it may come into force at some point in time, and another portion come into force at some future dates. So you cannot just, because a bill is now law, believe the entirety is law. So as a permanent secretary, as a director, as a first assistant secretary, a deputy permanent secretary, and so on, you want to be sure that the bill itself or the statute to which you're referring to in and of itself is law in its entirety, or the provision that you're looking at has already been enacted as law. So you can't ever be too careful about that. And you can get, if you're not sure, you will seek that advice from the Office of the Attorney General, because it will tell you whether the bill in its entirety or whether certain provisions have become law. Okay? All right, so these are just other features of the Westminster model that we've inherited. As we said, a written, sovereign, democratic state, rigid, flexible, supreme law of the Commonwealth, the role of a majesty, lawyers' opposition. I just told you what that's about. It's written into the Constitution. You can find it in several areas in the Constitution that speaks to the role of the leader of the opposition. And then, of course, bicameral, meaning two governments, the Senate and the House of Assembly. Together they form Parliament. When we speak about Parliament, we speak about the two organs, the House of Assembly and the Senate. And together, they are regarded as what we call bicameral legislature. Bicameral legislature meaning two. Several other countries in the Caribbean and around the world are unicameral, meaning they do not have a Senate. They only have the House of Assembly. But the Bahamas is bicameral, having the Senate and the House of Assembly. Is that clear to everybody?
Question, can you give us why that is so? Why we are still bicameral as opposed to?
Well, here's why it is so. Because we've inherited an unelected Senate. The Senate in the Bahamas is appointed by, under our Constitution, is appointed by the Prime Minister, who is responsible for appointing X number of senators, by the leader of the opposition, who is responsible for appointing X number of senators, and by the Prime Minister in consultation with the leader of the opposition to appoint the remaining independent senators. So you will see, and let me just jump to this, I'll come back to it. A lot of people dislike the fact that you have a non-elected Senate. Most of the times you hear people criticize the Senate as a rubber stamp. Did you hear that at all?
Yes.
Right. Also, people see the Senate as a ground for appointing persons to the Senate or to government who were previously not elected in the general elections. Also, they may appoint those persons because of their credentials, and the government may want to have certain persons in the government, or the party may want to have certain persons in the government with certain skills and abilities and so on that they do not have within their parliamentary body. So the Senate then is used in that fashion to be able to do that. Now, you would notice from the Constitution, you cannot be a senator unless you're over the age of 21. So that is part of the problem that we've been experiencing. And so if I should digress just briefly, we have a situation where in Trinidad, for example, when they went from a parliamentary democracy to a federal parliamentary system, where they then appoint a president, and the president was previously the prime minister, right? And when he became the president, the current prime minister wanted to put in the Senate a number of senators who were not elected in the previous elections. And A&R Robinson said, no, you're not going to fill the Senate up with rejects. And he initially refused to appoint them on the recommendation of the prime minister. And we almost had a constitutional crisis in Trinidad. Came very close to a constitutional crisis in Trinidad. But we'll see that a little bit later. I just wanted to just jump the gun and speak to that a little bit.
Professor, may I ask, please? In 2007, I think it was, the Bahamas came to a huge argument about the additional senators who were independent and that were supposed to be appointed in consultation.
I went to the court, as a matter of fact.
Yes.
Yeah.
I don't know if we really ever solved that argument, because I don't recall what it was.
The court did. The court resolved the matter. It came down to a very fine point of law, right? And the fine point of law was this, that the court, in interpreting the word consultation, to consult, the court merely said that the Constitution says that you must consult. It does not say that you must agree.
Agree.
All you have to show that you consulted. And once you can show that you consulted, you can still make the decision on your own. You do not have to accept any of the recommendation that came to you by way of consultation. That is what the court agreed to. And that was the nature of the decision.
Okay, in your opinion, the argument put forward noting that perhaps because of the numbers that were so close, the leader of the opposition had almost a right to name those, I think it was 4 persons. To what extent would you have said that the arguments put forward by the leader of the opposition at the time was credible?
I think the argument was credible, but as I say, it came down on the basis of what is regarded as judicial interpretation. Now, in judicial interpretation, it is standard on what the courts and how the court will, and what it will decide in terms of interpreting the law. Those of you who might remember the legal interpretation, which would be the literal rule, the golden rule, and so on, the purposive rule. So they can use any one of those methods of interpretation to come down on the side of what the Constitution says and what they feel was the Constitution. Now, whether or not the same would have resulted if the side was flipped is a question for debate. But the same argument came up a little early on. And that is why the court was able to go back. Prior to 2007, when the opposition also thought that they had sufficient to warrant at least one more appointment, and he never gave them that one extra appointment either. And so on balance, you might say the court was correct in its interpretation. Don't know. There may be another opportunity for them to look at it. I don't know. There was an opportunity now for them to look at it, but they never challenged it on the basis of the court decision. Does that answer your question, Chuck?
Well, it does. It does. But this whole brings up another kind of more immediate situation that is happening right now, and that is the role of the Speaker in the House of Assembly and the kind of position that he has taken, and to the extent that that is causing good governance within the public service and the Bahamas at large.
Yeah, unfortunately, a speaker, when appointed, is appointed for the life of the parliament. A speaker, once appointed, is appointed for the life of the parliament unless he takes ill or unless on his own recognizance he resigns.
He steps down, yes.
Right. So you've got to bear with that first. Now, in the United Kingdom, they've moved on beyond the process that we've inherited, because the Speaker in the United Kingdom, and I think one or two other Commonwealth jurisdictions, removes himself from his party affiliation so that he could truly become independent. But in order to do that, there has to be an agreement on both sides that his seat will not be contested for at least 2 elections, because he needs to appear to be independent. And I don't know if you will get that kind of concession.
No, sir.
Right. Unfortunately, the government has to grin and bear the situation as it now is, but also the Speaker has a glorious opportunity to show on balance how he manages the chair. You follow me? How he manages the agenda, because he does not set the agenda. The government sets the agenda. He simply manages the agenda. That's all. Okay? So,
no. What happens in the...
You just got cut off.
Okay. Sorry. What happens in the case if the Speaker resigns?
Then the Deputy Speaker becomes the Speaker.
Oh, thank you.
Not a problem. Any other questions so far? Okay. So as I said, these are the safeguards within the Constitution. We have these saving clauses. These saving clauses are clauses that the United Kingdom in the Westminster system put in to make sure that things previously before independence, you can't take them out. Like, for example, the issue of murder. That's why we are unable to get by the Privy Council in getting somebody hung.
Capital punishment.
Exactly, because those are saving clauses that you cannot move. Jamaica's tried to move them. Every Caribbean island tried to move them so that they can hang people. But what the Privy Council has done, because they were also part of the European Union was then for the United Kingdom had given up its how shall I say it, its independence. They've just now got back their independence after they left Brexit or break away from the European Union, because all of the laws that was done in the European Union, they became laws in England. And so the European Union, as you know, they're not big on capital offenses. And so by vertical legislation or diagonal legislation, all those became part of the British system. And so the House of Lords, which is now the Supreme Court in the United Kingdom, they were bound by what was happening in Europe.
I know, some of them wanted a biological break.
You can tell me when you want, so we can do that.
Oh, Mr. Mr. Sumner. May we take a break, please?
You want 5 minutes, 10 minutes?
Yeah, let's take 10.
Make it 5 minutes.
Yes,
you don't have to sign out. We just leave and come back in.
This is just too lively. 5 minutes.
Yeah, 5 minutes.
All right. Well, all those wanting to take a break, go and take your biological break and bring your coffee and tea back with you. And we'll carry on. If that's all right with Mr. Sumner, we could take 5 minutes and be back.
Yeah, let's take the 5 minutes.
Continue.
Let's take 5 and be back. 5 minutes.
Sumner, do you think you'll remember that last point you were explaining how the United Kingdom actually decided, you know, when they broke away, that it released them. Okay, so you don't forget. Okay, then.
Right.
Thanks.
Parliament, the different readings and the stages it goes through.
Right.
But I was trying to interject to ask a question at that time. But my question to you now is the fact that even when the first reading, the second reading, and you know, they discuss it and all that, and then it is now placed before the Parliament, and then they would have come to some agreement and they would have consented, I guess, together in that area, and then it's forward to the Senate, and then the Senate says, listen, I don't want nothing, or you have to modify it, they send it back, right? But if Parliament chooses not to modify it, or I think there's a time frame that they have alluded to in terms of what the Parliament can do by bypassing the Senate, and the Senate do not have to necessarily agree or vote to consent to whatever the bill is to become law. Am I
think the only, as far as my recollection of the Constitution in that regard with respect to the Senate, is that the issue of money bills.
Oh, so it's just the money bills. Everything else can.
Just the money bills, yeah.
So everything else would have to get the support of the Senate.
Yeah, they would. Notice what the Senate would do. If there is an agreement at the Senate to change certain things, they will then send it back to the House of Assembly for them to take a look at what their suggestions might be. And once they would have gone through it, the government could decide whether to accept or not accept. And if they decide not to accept, then they send it back to the Senate as, no, we're not going to change it.
But what the question I'm asking here at the end, when they would have forwarded back to the Senate for their consent, and the Senate is still holding off. I think there's a period of time, I'm guessing like 14 days.
I don't quite remember the actual length of time, but after that period expired, then the government could move on its own.
And so then they bypass the Senate and they send it to the Governor General, and then the Governor General would have to
yeah.
Okay.
Yeah.
All right.
So there was a question about the European Union. Is that person back in session? All right, I'll hold off until she gets back.
Yes, most persons could be back.
Yes.
We took more than 5 minutes, including myself, so we're all back in order.
Okay. So you've seen here, we talked about the saving clauses already, which I think what you would have been talking about, and the entrenched provisions, and the especially entrenched provisions, those are safeguards within the Constitution. And then, of course, we will talk a little bit from now on the issue of judicial review, which is where administrative law is strictly and critically important in terms of your action, because your action as First Assistant Secretary, as Deputy Permanent Secretary, as Permanent Secretary could give rise to an action being brought by way of judicial review for some of the decisions that you took or some of the decisions that you didn't take and should have taken. So when we understand delegated legislation, how important that is, you'll understand what I'm talking about. And then, of course, you've got the, as I indicated a little earlier, the Cabinet Manual of Procedures, which spells out for us how governments function. So we talk about the rule of law and the separation of powers. Here we would say under the Constitution, it says the powers are separated into three different organs. You've got the legislature, which is the Senate and the House of Assembly. You got the executive, which is cabinet, and the senior public service and all of its apparatus. I want you to understand that. So the permanent secretary, for example, is a constitutionally appointed post. If you look into the Constitution, it's one of few, the permanent secretary, the Chief Justice, the Commissioner of Police, all of those senior persons are statutorily appointed. So there's a statutory provision, and that's why they form part of the executive, right? And then, of course, you got the judiciary, which would be the judges or the courts and so on, da-da-da-da. And then you have what is considered to be, in terms of the executive, this notion of cabinet collective responsibility. What it simply means, and this used to be called also responsible government. Those of you who are old enough and perhaps even through your own education would recall the 1964 Constitution, which says responsible government. Responsible government meant collective responsibility. Now, here's the problem with this notion of the doctrine of collective cabinet responsibility and the rule of law and the independence of the judiciary. All of those came into force with each other in immediately following independence. Anybody can recall what that was about?
Was that the case of the Minister of Home Affairs versus Darcy Ryan?
Ryan, exactly right. The Minister of Home Affairs, Darcy Ryan, a Canadian Bahamian, who was in the Bahamas for most of his childhood and adulthood and married into a Bahamian family with children who themselves were entitled and were awarded Bahamian citizenship on independence. The government decided to decline or refuse Darcy Ryan's citizenship. Remember that? And it worked its way through the courts. Well, the Minister of Home Affairs was a cabinet minister, right? Is that correct? The cabinet minister on the responsible government could not have made that decision on his own, could he?
No, sir.
It would have had to been a collective responsibility. So the minister was merely saying to Darcy Ryan what the cabinet said.
Yes.
Exactly. So was there separation of powers? No.
However, Professor, I think we complicated that because it was noted that the Minister of Home Affairs at that time stated, whether officially or unofficially, that Darcy Ryan will be given citizenship over his dead body.
And that was the cabinet directive. Right? So the rule of law would say that everyone was entitled. The Constitution made him entitled. And the rule of law says everyone is subject to the law, no one is above the law, meaning even cabinet would and should not have been above the law. But the minister could not, on his own, grant citizenship without the cabinet approval. And so here these three branches of the government came into conflict. Now, also, part of the reason why there is no separation of powers as we know it to be, because the legislature in the House of Assembly, you've got the cabinet ministers, don't you? Those same cabinet ministers sit in cabinet. I mean, sorry, those same legislators sit in cabinet as cabinet ministers as part of the executive. So do you see the overlap?
Yes.
And then the judiciary, the Attorney General happens to be also the executive. So you see how there is very little, so to speak, separation of powers in this regard, because there is an intermingling. And then, of course, you get the Crown, who sits in each of these three branches. And so while the notion of separation of powers is there, it is not so much separated as much as it's a merger. It's a crossing over of the different, and which is why the rule of law and the independence of the judiciary is extremely critical for the fundamental, for how we manage the affairs of the country. But let me speed along a little bit. Okay, let me just move on. You will get these stuff here, so what I'm missing, that's fine, you can catch them a little later. Just very quickly, in terms of the rule of law, it says here, the most important application of the rule of law is the principle that the governmental authorities is legitimately exercised only in accordance with the written, publicly disclosed laws adopted and enforced in accordance with established procedural steps and are referred to as due process. Now, you can underline that word, due process. Anyone has the idea what due process means?
Due process is the process whereby all aspects must be dealt with.
Yeah, okay.
It is actually the steps towards the ultimate conclusion of the matter, that all steps are followed in according
exactly
the existing rules.
There would be certain steps and stages and processes that you must undertake in order for there to be procedural fairness.
Right.
Yes, sir. That is why you find so many instances where you take matters to the court, and if it's employment, you'd find that it might have been unfair, or it may have been wrongful, or if it's part of judicial review, you're talking about impropriety and procedural unfairness and so on, or what we call sometimes the Wednesbury principle of unreasonableness. Anybody would have come across the whole notion of the Wednesbury principle of unreasonableness is where the court is going to look for these procedural aspects that you should have got done and you didn't do as administrators. So the due process outlines the steps that you must take in order to arrive at a decision, a fair decision, not necessarily have to be right, but it has to be fair.
Mr. Sumner, can you repeat that process again? You said I didn't catch the name.
You have to, what, in terms of the due process, I'm saying procedural fairness.
Yes, but you call a name the Wednesbury?
The Wednesbury, W-E-D-N-S-B-U-R-Y. The Wednesbury principle of unreasonableness.
Can you spell it again, please?
W-E-D-N-S-B-U-R-Y. The Wednesbury principle of unreasonableness, which in a nutshell says no one could unreasonably come to a conclusion in the manner in which they did, because it would have been so unfair, so unreasonable to put in your mind. In other words, you can't just do something to me because you hate Leroy Sumner. You still must treat Leroy Sumner fairly.
So,
Go through
sorry, Mr. Sumner.
Yes, ma'am.
Sorry to interrupt. So for us as future FASs, right, or we aspire to that position, I think what you're saying to us is that we must also observe rule of law. We must know our work, know policy, and so that we can be fair to our stakeholders, and know policy so that you can follow process. So that you can,
because if you do not follow the process and procedures, the court is merely going to go ahead.
no, I wasn't speaking. I was trying to listen to you.
The court will look to see if you follow your own regulations, rules, and procedures.
Right.
And if you didn't follow those rules and procedures, then you know where they're going to go? They're going to go to Section 15 of the Constitution. What is Section 15 of the Constitution? The fundamental rights and freedom of the individual. And in that Section 15, it's like 18 or 28 fundamental rights that are guaranteed to the citizens under that Constitution.
Right.
Right?
So we must also know, like for me, it would be the Education Act, right? Whenever dealing with stakeholders, I must know those policies, and those policies should be in line with what is in the Constitution. They shouldn't conflict, right?
The Constitution is the supreme
law.
The Education Act is the statute law, and then all of your policies, regulations, and so on are regarded as the SI, statutory instrument, or what was the other word? Delegated legislation.
Yes.
Right.
And you must understand the difference.
I want to see.
The Constitution is the supreme law. The Education Act would be the statute law. All of the regulations and policies and so on would be the delegated.
Yes, I understand that, but we as public servants aspiring to leadership positions should have a good understanding of all of those.
A very good understanding of all of those. If you don't, then you must always seek advice.
Right.
Yeah, Professor.
Thank you.
Thank you. Professor, from time to time, most of us who are FASs and below, I call them street bureaucrats, because sometimes we seem to make laws or right on the spot through the decisions we make.
And you can't do that.
And you can't do that.
You can't do that. There has to be this procedural fairness. There has to be the worthiness of what you're doing. And the principle, it must conform to what's in the statute, it must conform to what's in the Constitution, and more so it must conform where you have your authority in the delegated part of the legislation.
Yes.
Right? Because
I think what it is that.
Hang on for a minute. More often than not, we overstep our bounds and we ascribe to ourselves authorities that we do not have.
Right.
And once you take it upon yourself to exercise some authorities that you do not have, you would have gone ultra-vires the delegated authority under that provision, and the court is going to strike it down. The court is going to strike it down. Or even some of the tribunals will strike it down. You've got the various tribunals that you go to as public servants in the first place, right? Anybody could name one or two of them?
Industrial tribunal.
Industrial tribunal.
Arbitration tribunal.
Tribunal.
And now the tax commission.
Court of Appeal.
No.
The
Public Service Commission. Tribunal. The Public Service Tribunal.
Service Commission.
Yes, the Police Service Commission. Appeals Board. You get the Credit Unions Appeal Board.
Yes.
Those of you on Customs and Immigration, you have your own set of regulations where you can bring people before them up on charge. You see what I'm saying?
Yes.
Right.
We now have the tax commission.
So exactly, you can go before them.
Too, eh?
You can go before them. That's part of what is considered to be the delegated legislation that gives authority to administrators to do what the government requires of them to do. But in doing so, you cannot go outside of your own set of regulations. You cannot believe that you're so all-powerful that you can ascribe laws unto yourselves. Because when they get before the court is going to strike it down. And so the rule of law then is very important in this case. And so Lord Bingham, one of the most noted jurists in the United Kingdom, he speaks about 8 principles of the rule of law. The first one, and these are not in any order of ascendancy or priority, but the first one he says that the law must be accessible. Yes?
Yes.
The law must be accessible and so far as possible, intelligible, clear, and predictable. In other words, because of cases, how cases are decided, because of how judges would interpret the law, right? And because of judicial precedents and so on, there has to be predictability if something should happen, how this was decided previously. That's why when you go into courts, on the basis of the complaint, you would know what case law has already been decided on the basis of what you've seen. And so you could almost predict the outcome, unless, of course, the judges may have reason to either strike it down or for some other reason. But this class don't get into that right now. So that's okay?
Professor, I agree. The law must, those principles, accessible, intelligible, clear, predictable. However, I would argue that we start with some contradictions even from the Constitution in the manner in which it is written that the common man cannot really understand it.
And that is not a contradiction. That is not a contradiction only because everywhere in the world, they have the same complaint about the citizenry not really understanding well enough the Constitution. And so what you try to do as early as possible is that you try to teach the Constitution, the constitutional law to your junior high school students, to your senior high school students, so that by the time you get out, you really have a good grounding in what the Constitution says and how it is interpreted, right? We're only 50 years old. America is 450 years or 300 years plus.
True.
And a lot of their citizens still do not understand the Constitution.
That's true.
You have to read it.
Is there any reason why the Constitution is not taught in the schools?
Oh, that's a decision for the curriculum people now. That one is outside of my purview. Okay, so the second one is
facets, Mr. Sumner, just for information, facets of the Constitution are maybe the detail that we would want it to be in because of the scope of the curriculum in that area. But Bahamian history and civics is integrated in the high school curriculum.
Thank you very much, Ms. Bastian.
Not in the depth that Mrs. Sumner is bringing to the table, of course.
Yeah, and so the second one by Lord Bingham is the questions of legal rights and liabilities should ordinarily be resolved by application of the law. See that? By the application of the law, how the law applies, and not the exercise of discretion. So you cannot, what the law says, fetter your discretion or fettering your discretion to make some decisions. The law is going to strike it down because you cannot exercise your discretion. You have to apply the law as it is.
But you could exercise your discretion, Mr. Sumner. But you have to exercise it reasonably. They have certain laws that state that the judge can exercise his discretion, but it has to be reasonable.
Yeah, it comes back to what I just indicated early on. There is the principle of reasonableness.
Right. So you can't exercise it.
So if you exercise it in the wrong way, then the court is going to strike it down.
I think in that way you'll avoid biasness.
Avoid bias.
But certainly,
the laws of the land should apply equally. Hello? Should apply equally. That's why you see so many challenges are coming up.
Yes.
it must apply equally. If you go back to the Fundamental Rights and Freedoms section of the Constitution, section 15, it points out very succinctly all of the fundamental rights. And I'll just read a few of them for you. Protection of the rights to life, that's the death penalty. Protection from inhumane treatment, hello?
Yeah, from torture.
Protection from slavery and forced labor. Protection from arbitrary arrest or detention. This is where immigration gets, and the prison and so on gets the government in a lot of trouble all the time. We spend a lot of money on that same section 19, eh? We spend plenty of money for putting people under arbitrary arrest and false arrest and long detentions and so on without getting them out of prison, right? Number 24
hours, yeah.
Mr. Sumner. Mr. Sumner.
Yes.
Yes. What about, like, you know, we have a lot of persons on death row. Yeah. And we know we can't we can't hang, the law doesn't allow us for right now because we have pending from the Privy Council about hanging.
Right.
So would they just stay on death row, or can their sentences be converted into life or something like that?
Some sentences have been commuted.
Okay.
Because even in prison, mind you, they have rights.
Yes, sir.
And when you trample those rights, it creates a constitutional problem for the government. That's part of it. That's part of the problem. Okay? And so, it should apply equally to all, save to the extent that the objective difference justify differentiation. So if there are some reasons why they cannot apply equally, then that objective differentiation would apply. Number 4 here, ministers and public officers like yourselves at all levels must act within their powers. Hello?
Yeah.
That's what is required with the rule of law. Ministers, public officers at all levels must act within their powers. Within their powers is called intra vires. That's the Latin word again, intra vires. If you act outside of your powers, it is ultra vires. Yeah?
Yes.
Okay. Number 5, the law must afford adequate protection of fundamental rights. Must afford adequate protection for all the fundamental rights that I've just outlined a while ago. So there will be some times, however, when those fundamental rights cannot be obeyed, can be put aside, but the Constitution tells you when those laws can be put aside and why, right? Okay, for example, right now we have these emergency powers orders. In the Constitution, it speaks to the emergency powers orders, which if you have such situations, the government can invoke these emergency powers to be able to suspend some of these fundamental rights and freedoms, so to speak. And number 6 means
Professor.
Must be.
Professor.
Huh?
Yeah, on that point where you talk about the suspension of the fundamental rights, here is where I have a problem with that, because you look at the same things that are being done in the United States, where governors would suspend fundamental rights. The action is then taken to court, and the court has found that this emergency order is unconstitutional.
Right. Now, we don't live in the United States.
I understand, but we follow.
So now we go to England, where they've already also taken the government to court for the suspension of some of these same fundamental rights and freedoms of the individual. And the United States, the British Supreme Court, which is the highest court in England now, has struck down their application which says that the emergency powers allows the government to be able to do that. So in terms of precedent, our courts would be bound by the precedent of the court in the United Kingdom. If you understand, and that's not to be insulting, the hierarchy of the court is such that the lower court, which would be the magistrate courts, they cannot have any binding precedents.
Because it can go to the Supreme Court.
They can go to the Supreme Court. The Supreme Court has the binding. Each level of the court binds the court below. Is that clear enough for you?
Yes.
Right. So the Supreme Court binds the decision of the magistrate court. The Court of Appeal binds the decision
of the Supreme Court.
And the Privy Council binds all of them.
All.
Where is the Privy Council?
In London.
Thank you very much. Okay? So number 7 says, judicial and other adjudicative procedures must be fair and independent. We already talked about judicial and the courts and adjudicative procedures. These are some of the, what you have in the public service now and in the credit unions and in the police service commission and all those other organs that make decisions on behalf of the state. Now, the court looks at, you don't have to just be a ministry that makes a decision on behalf of the state. The court cases and ruling is that any body, any organization, any organ that makes decision for and on behalf of the state can be taken to the court by way of a judicial review and for sanction. Because once you accept public money and you make decisions on behalf of the government, road traffic, for example, any of the other outlying, they are susceptible to go, or if you go to any of the College of Bahamas, whatever, autonomous bodies, doesn't matter. Once you accept the government money or you're part of the government organ, then you are eligible or liable to go before the courts. Number 8, which is the final one by Lord Bingham, there must be compliance by the state with international legal obligations. Must be compliance by the state with international legal obligations. And so sometimes we as administrators, we as citizens do not quite understand the obligations when we form these alliances with international agencies, international organizations. They have their own constitutional provisions that we ascribe to. And so Lord Bingham is saying there must be compliance by the state with our international legal obligations. So the United Nations, World Food Organization, WHO, you name them, UNESCO, whatever organizations that we are part of, there should be some compliance with those obligations. And the rule of law and the separation of powers are therefore central to the legal foundation of public administration. So we're getting into,
Mr. Sumner, with respect to the, what you've just mentioned with regard to legal obligation to international treaties. Now, I know we sign on to a lot of treaties, but we have to bear in mind, I would suppose, that these should not trump our Constitution. What if some of these international laws and treaty go against our Constitution? How will we expect to follow?
No law supersedes your national Constitution, right? And so where there may be instances where in some of these international conventions and constitutions, you would notice that the government may enter some provision to not accept or accede to certain things, certain conditions. Also, you would notice that in some of the international organizations, the government will bring those constitutions to Parliament to have Parliament actually accept them as opposed to just the executive.
Mr. Sumner. Hi, Lucretia here. Also, when just to add to what you said, the government also allow our legal partners, the AG's office, to look over these agreements in order to decide on whether or not they're going to accept certain provisions on behalf of the government.
Yes, and they would advise the government, and that's what I'm saying. Sometimes we will enter some notion that we will not accept certain aspects of them.
Mr. Sumner?
We're coming up to the end.
Yeah, Mr. Sumner.
Yes.
I'm advised that you have lots and lots of information to share, and you only have an hour left.
I'm gonna skip some of this right now, Elma.
All right, so you might want to speed it up, although your participants would love to have you here all day.
Okay.
And we are all learning.
Having said that, let me move to administrative law.
Okay.
Okay, so what is administrative law then? Administrative or public law has been defined by Midland as the law which determines the organization, powers, and duties of administrative authorities. In the administration of social services, for example, and in the regulations of the economic activities, individuals come into contact with the public officers or public bodies. In disputes arising out of interactions, the individual has recourse to the court to address or redress by way of judicial review anything that might have been wronged or they feel that they might have been wronged. And what is judicial review? It is a process whereby the courts would examine the process employed by the public officials to determine whether there has been any illegal, unfair, or unreasonable conduct on their part sufficient to cause the court to squash an action that was taken earlier and so on. Okay? And so let me just go with some of the constitutional provision under the administrative law. Persons or companies can apply for judicial review of actions or decisions by the local authorities, by the public service, or government ministries to ensure that they comply with the law. Secondly, there is also an overlap between the two. For example, the constitutional limitations on delegation of authority to the administrative authorities and those provisions of the Constitution which restrict administrative action, such as the fundamental rights and provisions, and how government ministries, departments, and agencies are set up and managed, and the powers and authorities they can exercise. So whatever those powers and authorities are, you have to exercise those within the discretion of the law that has been delegated to you. So let me just skip that one. Some of the conventions that I've mentioned earlier, because we've got to also remember some of these. You will see those there. I'm just going to skip those off for the time being. I think we would know quite a bit of what these conventions are. They keep coming up, but let me just mention one or two of them here. The resignation of a minister if he is in breach of his duties or obligations. Now, that's a constitutional provision. It is also in the Cabinet Manual of Procedures. You've seen this happen over and repeatedly. Over and repeatedly. You can recall a minister, Sidney Colley, for example. Anybody remember that?
Yes, the local government elections.
There you go. And what happened there? He had to take responsibility for his senior officer.
He had to resign.
And there was no law to say, but he had to take responsibility for the senior officer because the minister is in charge of the ministry.
Yes, and so did Minister Urban Knowles, did he?
So did Minister Urban Knowles, right?
Yes.
So I'm just trying to show you how the Westminster model has cause us to be able to behave in a certain way in terms of public administration, so you'd understand how the system works. And if it works, if it is intended to work, it's a beautiful system, but I think it also has run its course. The government is expected to resign if it loses a no confidence vote in the House of Assembly, because there would have been no further confidence of the government, so it has to go to Parliament to go to the people for fresh elections. Those are part of what we are understanding as governing administrative law in the Bahamas as well. I talk about the one with the monarch giving a royal assent. The appointment of the Prime Minister. The appointment of the Prime Minister is done by the Governor General after an election, and it is determined whether his party holds the majority of seats. Notice that the Prime Minister cannot appoint a single minister until he himself has been sworn in by the Governor General.
That's right.
So the Prime Minister has to wait until he has himself been sworn in before he could invite or recommend to the Governor General his cabinet. Now, who is the first person that he would recommend? Anyone?
The AG, the Attorney General.
The Attorney General. And that is because he is the advisor to the government.
That's right.
And the Attorney General, and the
Minister of Finance.
Finance.
Yes. You can look at the order of the plates on the cards, and that will tell you the order of the government, the seniority of the people in the government. If you want to know who's senior in the government, in the cabinet, look at their cabinet plates.
Public Works.
All right, that'll tell you. But the top two would be the Minister of Finance and the Attorney General. That's part of the administrative law that we all understand. As you go up in the system, you'll understand how the system works. Cabinet ministers are expected to resign if they vote against the government or disclose cabinet proceedings. Hello?
Yes. Indeed.
It just recently happened, did it?
Yes.
These were not necessarily cabinet ministers, but they were parliamentary.
Yes.
And they voted against the government. So the Westminster system of government says what? You should resign. If you don't resign, the Prime Minister has no other recourse than to let you go.
Yeah.
That's the system we have inherited. You all understand what I'm saying?
Yeah.
Okay. So they cannot speak publicly about the confidential cabinet matters. If you speak publicly, then it gets back to the Prime Minister.
Former Minister of Works.
You get fired.
Yes.
Huh? Okay. Stuff like the monarch does not go to the House of Assembly. She has to be invited at the opening of Parliament. And notice, even when she used to go to the House of Assembly, it had to be by invitation. Even the President of the United States cannot go to Congress. He has to be invited to go into Congress. Into the Senate. And of course, judges should not play an active role in political life. Why? Because you want to maintain the independence
Partiality.
Of the judiciary.
Impartiality.
Yes.
This word is criticized, so you want to correct that for me. Members of Parliament should not criticize the judiciary, because Parliament has to be removed in terms of separation of powers from the judiciary. Even though they may not like some of the rulings of the courts, you cannot publicly disclose that in terms of public administration. Okay? And of course, I said to you earlier, the Prime Minister must be a member of the House of Assembly, Ministers are collectively responsible to Cabinet or to Parliament. We just indicated the issue of the Darcy Ryan case as a classic example on the issue of separation of powers, the rule of law, and where the power base lies in the three organs, eh? You remember Miss Darcy Ryan, said to the minister that he should decide Darcy Ryan's application in accordance with the law. And if he didn't do so, he would be held in contempt. Remember that? Hello?
Yeah,
yes. What did the former prime minister say? The former prime minister said, oh, if you're going to hold him in contempt, you better have enough space in there for my whole cabinet.
For all the cabinet, yes.
There you go. Why? Because cabinet is
the decision making. Yes.
And rule making, and the minister cannot speak for himself. When the minister speaks, he speaks to the cabinet.
Yeah.
Which is why whenever you as the permanent secretary or a deputy or an undersecretary rely on an officer below you for information, you better make sure that that information is correct. Otherwise, you may cause the minister to mislead Parliament.
That's why you're supposed to show them the policy.
You understand how important this thing is?
So that's why you have to do your own work.
You not only do your own work, you have to make sure that the information is correct. Permanent secretary is absolutely accurate. Okay? So these are the important things that we have to understand. Okay? And then, of course, you got the binding principles of the rules which derive from the practice, So, but I have to speed this along. We talk about collective responsibility. So just want to mention one or two things there with a collective responsibility, which I think all of you all should keep in mind also, is this notion here of the unanimity principle. The unanimity principle simply speaks to you can have your differences as a minister and you can air those in cabinet. Now, somebody in cabinet will tell you a little later on that you don't take ministers in cabinet like that. And when the cabinet makes a decision, that decision is binding on every minister. And once that cabinet decision is taken, that's where this unanimity principle comes into being. It's unanimous. You cannot go out to the public and say, I disagree. The minute you say that, you hand in your resignation or you get fired. So you can understand these principles that govern administrative laws in the country. The confidentiality principle, which allows for frank ministerial discussion within the cabinet, because you cannot say who said what, and they are free to speak. But once the decision is taken, that unanimity principle comes into being. It's unanimous. You walk out of cabinet as if you have agreed all along. Okay? Now, where an individual minister makes a decision without coming to cabinet, that is called an individual minister responsibility. And therein lies where he can get fired. Because if he did not bring to cabinet anything that is happening within his ministry to inform cabinet or to get any directive from cabinet, then he takes that responsibility all by himself. And you wouldn't find too many cabinet ministers supporting him after that. He perhaps will have to leave. And so also the convention that says that they take responsibility for the conduct in his public role as minister. And you've seen this earlier on with the senator, who was also a junior minister, and his public conduct raised some eyebrow. I think it was in one of the Family Islands. And by the time he got to Nassau, the former prime minister, one of the prime ministers, had him fired. That's part of the system we have inherited. So the conduct in his private life is very important. We've seen this also when a former parliamentary secretary was accused of battering his wife. And the Prime Minister removed him as a parliamentary secretary. That's the system of government that we have inherited. It's higher than the rule of law. It's higher than, it's not written in the law, but these conventions are stronger, have a stronger force than law. Okay? Okay, so carrying on with the administrative then, it is amalgamation of the public law and constitutional provisions, as I just showed you, legislative statutes and judicial opinions, executive directives, all of those constitute administrative law that address democratic legitimacy, control, and performance of administrative authority, and the discretion by specifying the legal structures, procedures, and standards utilized by government agencies with emphasis on the role of institutional oversight by the courts. That is the issue of judicial review. And it goes on to tell you what administrative law does, regulates the procedures agencies use in adjudicating lawmaking, adopting policies, control the exercise of their authority to enforce laws and regulations and govern the extent to which administration is open to public scrutiny, has to be transparent. And secondly, provide for the review of agency decisions, rules, orders, policies, actions, and so on. And then number three, it regulates how public administrative agencies do what they do and why, and as a result, their authority to do it. If you don't have the authority to do it, you're acting outside of your authority, da-da-da. Okay? I don't mean that y'all should stop talking now. Okay, so here is the relationship then between constitutional law and administrative law. The Constitution and public law govern the affairs of the state, both of them. In the state with a written constitution such as the Bahamas, the source of constitutional law is the Constitution. All other laws are subordinate to it. The source of administrative law includes statutory instruments, precedents, customs, regulations, policies, etc., etc. Constitutional law describes the various agencies of government at rest. Administrative law describes them in motion. So says Holland. The structure of the executive and the legislature come within the purview of the constitutional law, whereas the functioning is governed by administrative law. So I hope you're beginning to see the relationship. It's a symbiotic relationship. The Constitution, however, is the supreme law. No other law can supersede it. Any law inconsistent with the Constitution is ultra vires. Any question there? Constitutional law lays down the fundamentals of the workings of the government organs, while administrative law deals with the details. That's what you do as administrators, the details of the laws which you carry out. Constitutional law is, as I said, supreme. I don't go back through that again, let me just see if I can get down here to, because time is running out on me. Okay, so we go here and we look at chapter 4, article 32 to 37, that sets up the constitutional office of the Governor General, and it defines for you all of the powers of the Governor General, that section. And the Governor General can only act within what the Constitution ascribed to him to act. And there are very few instances in the Constitution when the Governor General can act under his own authority. Very few occasions when that can happen. And the main one is when he selects his own staff. The public service will not have very much to do with the selection of his staff. They will give him a list of possible persons and he will choose from that list who he wants. And once he chooses from that list who he wants to work with him, he has total control over his staff. They do not then come under control of the public service until they revert to becoming public servants. But I guess the officers tomorrow and later on will speak to you a little bit more about that. In Chapter 5, Article 38 through 70, the composition and functioning of the Parliament, we just spoke to that. We talk about the Representation of the People Act that tells you how parliamentarians are selected and so on, how those elections are to be held. But the Constitution itself tells you who can be candidates. Okay? Let me just go to this one here, the types of legislation. I've indicated to you very early on, you have the statute law or the primary legislation or enabling act. This is the law that goes through Parliament and become a, once it goes through Parliament as a bill, after that it becomes a statute law. And there is another law that speaks to the statutory instrument or delegated legislation. These are the regulations that governs the public service, for example, the public service regulations, bylaws which govern credit unions, for example, policies, procedures, and so on, how you hear complaints from the various tribunals, the Public Service Board of Appeal. Those were the things would be delegated legislation, statutory instrument that tells you as administrators how you are to manage your affairs in your particular ministry. So that is where you're going to be looking for the delegated legislation. And you have to deal with the delegated legislation as they are written in your policies, in your regulations, in your bylaws, in your whatever they might be. So administrative bodies, agencies, ministries, etc., how they manage their delegated authority, how they handle the details. And then, of course, we've got the next one here that speaks to the common law, which are things that have inherited hundreds of years ago in terms of how we act, how we behave towards each other, and what the law might say. Okay, any question there? Because I'm trying to rush this now. My time is fast going, right, Elma? Okay. Any question there, please? Everybody's on it.
No, we're here.
We are here, sir.
We're here just exciting.
We're here.
Just absorbing what you say.
They realize you have a lot to present.
Well presented.
Listening attentively.
Okay. Well, let me hit the last one, because we're running over the time, right? I think my session should finish at 12:30, eh?
Yes, sir.
I think so.
So, yeah, that's why they went quiet on you, because they want you to finish this.
That's right. You're going to finish now. So the other question there is that why is the Constitution important for the stability of good governance? I've just indicated a long time ago why that is so important. Some of the things here, the Constitution contains the most important rules of our political system. That's why it is important. We have to obey those rules. Anytime we go outside of that, the Supreme Court will bring you back in line, because the whole notion of the court is that it is independent of the government, and it must be able to adjudicate when even the government, as big as it is brought into the courts and made to at least comply with what the Constitution requires. The Constitution, as I said, is the law of the land. How and why, what means the Constitution can be amended, all of those things are what brings stability to the governance. And of course, it sets out the institution of government, and the role and so on. And I don't want to take this moment now to write down any of the reasons why it is important, because I've just given you some of those. And stability in this case is a prerequisite for a stable democracy, because people understand the rule of law, the application of the rule of law, and the segregation of duties between the three organs of government, and how important it is that the government does not do anything arbitrarily or capriciously. And that is why the stability of the government, of the Constitution, is so critically important. The certainty in the law, the application of the law brings also stability, because you would know if something happened, how the judges are going to rule, how they're going to be interpreted, because these are case laws that they follow from many years over, and once they have not been changed, they become the laws of the land and the laws which must be followed. Judicial review, I don't know, did y'all get a one-pager from me on judicial review? Anyone?
Yes, it was sent and it's also on the SharePoint.
Okay, so it's in SharePoint, so I'm not going to go through it now, but you would need to understand that as well. The public service is the delivery system. They're responsible for the hiring, the firing, the disciplining of everybody who works in the public service. But in doing so, the public service itself is bound by its own set of regulations. And you remember that issue about the due process? That has to come into being in due process to make sure that those things follow the letter of the law. And there is this issue of accountability that must be taken into consideration, and the certainty of the application of the law has to be also critically important there. And also other factors would be self-stabilizing. So that would be the peaceful political transition process. I mean, you know, there's election every 5 years, which you have to do in order to put the election in place. So that is comforting to the public. It is comforting to the international community that there is this stability within the political system that we have. We don't go by the bullet, we go by the ballot. And certainty of elections, there's an election court. If there are grievances, so you can go to election court, the election court will make the determinations. Those are also parts of the stability of governance. And the limit on legitimate government action, so that you know even that the government is above the law, and the consensus that follows the citizen in a democratic way to remove officials and governments if and when it becomes necessary, and the adaptation of to different conditions. There were some other ones here that I wanted to speak to, but the time is fast passing. So any questions before I?
Yes, Professor, my question is, in today's environment, and we are talking about robust government, and particularly dealing with turbulence conditions in society. For example, COVID-19 caused government to adopt rules and regulations that Bahamians never even thought about. How now are we supposed to govern and get towards good government and all of that with all of these changing conditions, and while at the same time manage within the law? How do we creatively adjust these laws to make them relevant to the conditions?
Exactly. That is why you have statutory instruments. You cannot change statute law easily, but you can change the statutory instrument easily. So whenever you amend a policy, whenever you amend a regulations, as the public service might do from time to time, whenever you do those things, they become what is regarded as the statutory instruments that will govern your procedures. You understand what I'm saying? That is why you have these delegated legislation to allow you to be able to make changes as and when they become necessary, rather than going to Parliament to amend the statute law. You could amend the regulations. You could develop new regulations. You could do all of those things. Now, but when you do them, what the court will say and what the government will say is that they should at least be given to the minister, depending on how wide those amendments are, and the minister ought to lay them in Parliament. They don't have to be debated, but just lay them in Parliament and approve them, and they become a revised set of regulations, a revised set of policies, a revised set of whatever have you.
Okay, so Sally again, Mr. Sumner. So, you know, earlier I asked about the rigidity of the Constitution. So these are the aspects of it that would allow us, like you were saying, this
Right.
to be fluid, to change with the times.
The statutory instruments allow you to do that.
Okay.
And remember we said statutory instrument, or sometimes we call the delegated legislation, right? Or the secondary legislation. All of those things are what is required to make sure that the public service would be in a position to keep up with any changes that are necessary. Any wide sweeping changes, you would know, the permanent secretary would know that those policies and regulations, once they're formed, they go to the Attorney General's office, they are fashioned, and they will come out as an amendment to a statutory instrument for that particular department. There was something here that I wanted to point out, but I might have passed that frame, but that's okay. In terms of the delegated legislation that speaks to, you talk about the Kaltuna principle. Anybody knows about the Kaltuna principle? That whole notion of delegated legislation, which allows the minister to delegate to his permanent secretary. But there are some instances in the Constitution or in statute law that will not allow the minister to delegate, that the minister himself has to do certain things. But he can delegate a lot of what he does to his permanent secretary. You perhaps will hear a little bit more about that, I don't know, later down in the week, in terms of, I hope I mentioned the Kaltuna principle. Now, finally, the notion of whether we go to a republic or we remain a parliamentary democracy, I think that was part of the question. The issue here for us is that Barbados is moving to a federal parliamentary system. Trinidad has done so. We are beginning to see that there is an appetite for Caribbean countries to move away from strictly the Westminster system of government to the formation of a federal parliamentary system. Okay? And I believe the Bahamas will not be terribly far away from that happening, at least in the next 5 to 10 years. Any questions?
Mr. Sumner.
Speak.
Okay. Can I then ask how should we as a country provide continuous education to the citizens of our country? Because I felt as though if the general population was aware of the Constitution and the powers that the government has and why they can also be held accountable if they're ultra-virus, that during this pandemic, we probably would not have had such a pushback for the curfews and the lockdowns and the wearing of masks. And so I see the articulation of the Constitution, whether it's in school, university, certainly I don't think anybody at my level or above who holds public office should be appointed without this information, because as public servants, we have a serious role in ensuring that our employees are aware of how governments function, and so on. Over.
Well, you know, just prior to us obtaining independence, most or several of our would be permanent secretaries, because we were then just getting into cabinet government, ministerial government. Many of them had gone to England also to be trained in the workings of the government and the role of parliamentary permanent secretaries and so on. And then, of course, we had people who had come to the Bahamas out of England and elsewhere, because the parliamentary system functioned everywhere in Commonwealth countries the same way. And so you could take a permanent secretary and put him anywhere in the Commonwealth countries and he could function because it was standardized across the process, right? But to answer your question, the issue would be more education in respect of our understanding of these constitutions that govern us, and not only of the Constitution, but the interplay between the Constitution and administrative law. It should not only always be in the purview of the courts to make those fine distinctions. Every public officer ought to know the boundaries in terms of administrative law and how it impacts their decision, how it impacts the rest of the governing of a country. That's critically important. And if you look at the one page, I'm going to finish right now. If you look at that one page that I sent you, that actually outlined for you the process of judicial review. The process of judicial review, it will show you the situation here. I'll just read it very quickly for you. It is called the anatomy of a challenge by way of judicial review. You got that one, didn't you?
Yes, sir.
Otherwise, I will have to send it to you. And I'll just go to the grounds for establishing ultra vires, for example. They talk about illegality. That means you've done something contrary to public policy. And under illegality, what would happen there? The court will look to see whether or not you abused the power that was given to you under the delegated authority, or you never used the power that the court that was given to you under the delegated legislation. So whether you have jurisdiction to use that power or not, or you went beyond the power that was given to you, or you unlawfully delegate to yourself power that you didn't have, right? Or the failure to carry out your duty. They can go back to the court and force you to carry out your duty. Or you surrender your discretion, right? Absence of a discretion, or you work in bad faith because you dislike somebody. And what is really worst of all is that the breach of human rights. Human rights all around the world now is taking precedence. So you want to be careful about that. And the human rights are, as they are ascribed in Article 15 of the Constitution, and then you have used the wrong purpose to make your decision. All of those come under the issue of illegality and would be grounds for the courts to cause something else to happen. The second one is the irrationality, or sometimes we call the Rensby principle of unreasonableness. I mentioned that a little earlier. And so here you are taking into account irrelevant factors or failure to take into account relevant factors in your decision making. That is what somebody will bring to the court to say, this is what happened, this is what you do, or this is what you didn't do. And then the proportionality of how you did that. The grounds would be whether you abused the power, that you exerted too much authority, too much power in arriving at a decision that you made. And the court would then look at that to see what, in terms, if you exercised the right proportion or you exerted more proportion than you really had. And then, of course, the third one would be to procedural impropriety, which would be the issue of natural justice. And in that issue of natural justice, you're talking about bias, whether you were biased towards something or somebody, whether you offered them a hearing or not, you just dismissed them, you just didn't want to hear what they say, and you didn't hear the other side, that kind of stuff, right? Or whether there was an error in the law on the record of what you've done, okay? So the courts then, having heard the application for judicial review and deciding whether or not there is sufficient evidence to move forward, the court may then, the remedies available to you then would be, the court may squash what you have done, issue an order of what they call certiorari, a squashing order that will undo the decision that you made previously and make it as if it never happened. Okay? Or it may order an enforcement order, which is the same as mandamus today, and it would make an authority fulfill his statutory duty. Now, it's too late for me to give you all the cases in this, but that's what will happen. And then the court may issue an order of prohibition. The prohibition is stopping you as the authority from acting unlawfully, if that is what they brought you to court for. Or in the case of the prison, as you've seen, in the case of immigration, in the case of prison officers, you may see an issue of habeas corpus, to show the body, to remove the body, to take them out of the prison because they'd been there too long and it was an offense. And then you might see a declaration. They may go to the court and ask for a declaration, that is, to explain what the law is and why you should be able to exercise or not exercise the law if you're moving outside ultravirus of that. Okay? So those are just some rough and ready aspects of how the Constitution is the stability of good governance in any country in the Westminster system of government.
Good day, Professor Sumner.
Yes.
Can I ask a quick question, sir? In our quest for constitutional reform as it relates to the Bahamas, do you foresee any changes being made to the preamble, in particular, an abiding respect for Christian values?
Of course. The Bahamas is becoming a multi-religious country, and they not all perhaps subscribe to Christianity. It's going to be a hot day in hell to get a change, and it may not come immediately, but at some point in time, they may amend it to reflect religion generally. I don't know anytime soon, but that's a legitimate contention.
Very much so, sir. Over and out.
Okay, any other question for me before I tell you thank you very much, and it was a pleasure?
One thing I just saw I want to, in my own mind, in terms of CARICOM, how does the meetings of CARICOM leaders fits into a constitution, or it's just something leaders find themselves having to use to ensure the uniformity? Because if the Constitution is uniform throughout the Caribbean, how does the CARICOM government plays into that constitutional model?
Remember now, we all in the Caribbean are still under the same Westminster system of government, but all of our constitution is still sacred to the individual members of CARICOM. They do not touch your constitution. And you would notice even with the constitution, so to speak, of CARICOM, we've entered a number of reserve clauses. That's the word, reserve. For example, the free movement of people. We've said we reserve on that. We do not accept it, and they will not force us to be able to accept it and to bring people in as they choose. We reserve the clause and we amended to include maybe just people in sports, people in the arts, people in medicine, and so on. but not general provision for persons to come in.
Okay.
So that's
Mr.
part of
Sumner,
what's happening in
Professor.
I'm sorry. Mr. Sumner, could you elaborate on what you said earlier with regard to a minister being able to delegate some of his responsibility to his permanent secretary, especially in instances?
It is called the Kaltuna Principle on administrative law. I thought I sent it to you, right? It is called the Kaltuna Principle where because the minister cannot do everything and the minister is responsible for his ministry, that the provision is there for the minister to delegate certain aspects of his authority. And that's why you see a permanent secretary can sign for and on behalf of the minister. That's the Kaltuna Principle right there. I'm just—
All right, but ladies and gentlemen, I think there are 75 participants back and Ms. Johnson is ready to go. In fact, she was up and running while we were still having our little huddle as assessors. Yesterday's presentation was a wonderful, useful, practical, eye-opening session for those of you who are hoping to become FASs and those who are even moving further up in this whole process. So, Ms. Johnson, we don't need any more. Your work spoke for you and all the experiences. And so we simply leave the floor open to another informative and inspiring message.
Thank you, Mrs. Garraway. This afternoon, we are looking at the Cabinet Office and the Office of the Prime Minister. And these are two of the ministries that are headed by the Prime Minister. So let's look first of all with what do we mean by the Cabinet Office? Who is it that we are speaking about? So the Cabinet Office is located in the center of the city of Nassau in Rawson Square. And it is a typical pink-hued building in keeping with the old colonial decision to create and to paint its buildings pink. It is named in honor of Sir Wilson Churchill, who came to the Bahamas in December of 1931. He came to recuperate because he had gotten in an accident, and he came to the Bahamas to convalesce. I've put here on the screen the excerpt from the Daily Tribune of January of 1932, which said, "Mr. Churchill is an ill man. He has come to Nassau to recover his health and strength, a great compliment to Nassau, which will greatly enhance its reputation as a tourist resort. Already he is feeling the benefit of our cure-all sunshine. It is for all of us to help him get well again. He should be kept quiet, should not exert himself." And that is how the building that houses the Cabinet Office came to be called the Churchill Building. I thought to include that because I was quite surprised about 2.5 years after I had been in the Cabinet Office to ask someone, when I saw a picture of Churchill pushed aside, if they knew who he was and why the building was named after him. And since the answer was no, I thought we would start out today by saying to you that the Cabinet Office, the proper name is really the Churchill Building. I'll talk more about that later on. Now, the Churchill Building is the premier seat of the Prime Minister of the Bahamas. So let's have a look at these prime ministers and premiers and see who these were and when the governance moved to the Churchill buildings. Let's start with Sir Roland Simonet. Roland Simonet, I'm going to read these very quickly and I may skip out some facts as we go along. He served as chief minister between 55 and 64. He was premier from 64 to 67. He is the longest serving parliamentarian ever and the first Bahamian to occupy the Cabinet Office in the Churchill building. And this is important because it signified the removal of the running of the internal affairs of the country from the Governor General in Mount Fitzwilliam to the Churchill building in Rawson Square. He was succeeded by Sir Lyndon Pinley. Now, as you know, Sir Lyndon Pinley, or you may or may not know, he was not always prime minister. He was styled premier from 1967 to 69. and he was prime minister from 69 to 92. He led the country to majority rule in 67 and on and through independence in 1973. So Lyndon is famous for winning an unbroken string of general elections from 67 to 1992. In fact, I think at one time he was in the Guinness Book of World Records. He introduced national insurance and expanded education for the masses and retired from public life in 1997. The next Prime Minister of the Bahamas was the Right Honorable Hubert Alexander Ingram. He was Prime Minister from 92 to 2002 and again from 2007 to 2012. He is credited with facilitating the Atlantis Paradise Island Resort, making the Bahamas a mega tourism mecca. He is also credited with removing influence peddling from government and restoring integrity and honesty to public life and introducing initiatives to achieve efficient and effective government. He also removed a monopoly from broadcasting. And for those of you who are fairly young, you may not realize, but at one point in time, ZNS was the only broadcasting station in the country. Prime Minister Ingram is followed by Honorable Perry Gladstone Christie. He was Prime Minister twice as well, from 2002 to 2007 and from 2012 to 2017. He was the youngest ever senator to be appointed, and he is the second longest serving parliamentarian ever. He introduced urban renewal and VAT and established a constitution reform committee to look at reforming the constitution. And then he was followed by the current Prime Minister, Dr. Hubert Minnis. He is the fourth Prime Minister since independence. The Prime Minister in our system of government is primus inter pares. This is a Latin phrase meaning first among equals. And as the Prime Minister is the first minister, so is the Cabinet Office the first ministry. Let's look at some of the work that these Prime Ministers have done for us. And let me begin by saying, in addition to all the work they do nationally and internally, they are our chief diplomat. Whenever major international events are taking place, it is our prime ministers who go abroad and who represent us. Here you see a clip of, this is a very good clip, this is Lyndon Pinling as he was then. He was premier. There's also a picture of Roland Simonet, who was the former premier, and they are at the Bahamas Constitutional Conference in London in 1968. There's another picture of Prime Minister Lyndon Pinling at Chogum, the Commonwealth Heads of Government meeting in Zimbabwe in 1976. And he's seated between UK Prime Minister Maggie Thatcher and Kenneth Kaunda, who is President of Zambia. Then next we are followed by a picture of Prime Minister Hubert Ingram. He is pictured with Barack Obama, who was President of the United States. And again, this was at a summit meeting where the United States was making a promise to improve relationships with the Caribbean countries. There is another picture in this slide. This is Prime Minister Ingram again, sitting with US President George Bush. He's meeting with other Caribbean leaders and President George Bush in the cabinet room at the White House in 2008. Prime Minister Perry Christie is pictured signing the historic Paris Agreement at United Nations in New York in 2016. And this is the agreement where nations pledged that they would do something about global warming. This is another picture of President Barack Obama along with Prime Minister Perry Christie, and they are having a chat in 2015 in Jamaica at the US President's Summit with Caribbean leaders. The final two pictures are of the current Prime Minister. Here we see Dr. Minnis at the 925th ACP meeting of the Committee of Ambassadors, again urging climate change in 2019. And there's a picture of our Prime Minister with Queen Elizabeth, who has received him during Chogum at Buckingham Palace in 2018. So these are the Prime Ministers. These are the men who have been in charge of our cabinet. And these are the ones who has led us into cabinet governance. Now, what exactly does the Cabinet Office do? What is it that these men do for us? The Cabinet Office is located in the center of the city of Nassau, named in honor of Sir Winston Churchill. It falls under the portfolio of the Prime Minister, and the Cabinet Office functions as the secretariat to the cabinet itself. The Cabinet Office is responsible for the management of government and parliamentary proceedings. The Prime Minister chooses the portfolio allocations. He chooses the name of ministers. He chooses the departments of government under each ministry. And he chooses these in light of the economic realities and the needs of the country at that time. No discussion about the Cabinet Office is going to be complete unless we discuss and include the activities of the Prime Minister. Prime Ministers decide which ministries will come into existence. In 1977, Prime Minister Pinling created a Ministry of Youth, Sports and Community Affairs. In 1989, Prime Minister Pinling decided Consumer Affairs was worthy of his own ministry, and he created a Ministry of Consumer Affairs. In 2012, Prime Minister Christie created a Ministry of Grand Bahama. And in 2019, Prime Minister Minnis created a Ministry of Disaster Preparedness, Management and Reconstruction. You will recall yesterday I said to you that ministries were temporary, but departments remain. And this is another example of that. As the needs of the country become paramount, prime ministers have the authority to create a special entity to deal with those particular needs. With regard to the allocation of portfolios, the Cabinet Office, one, arranges for a press release of the allocation of portfolios and publication in the Gazette on the occasion of the change of government or a major reallocation of portfolios. What is meant by that is once the government changes and a ministry is brought into being, it is the Cabinet Office's responsibility to publish in the Gazette the name of the ministry and the matters that come under those ministry. If during the term of an administration, the Prime Minister decides to move matters from one ministry to the other, that is again done in the Cabinet Office, and they are responsible for publishing that information in the Gazette. The Prime Minister is responsible for appointing ministers. Under Article 77 of the Constitution, the Prime Minister advises the Governor General to appoint a member of Parliament to be a minister. He decides the allocation of portfolio matters, and he decides the departments of government assigned to each minister. The Cabinet Office plays an integral role in this decision-making, in advising the Prime Minister and also in transmitting the Prime Minister's recommendations and advice to the Governor General. The document from the Prime Minister advising the Governor General is prepared in the Cabinet Office, and the advice from the Prime Minister when he wants to revoke the appointment of a minister is also prepared in the Cabinet Office and sent to the Governor General. There was a question yesterday about to whom should a letter of resignation be addressed. And I just want to reiterate that letter of resignation should properly and as a matter of courtesy be addressed to the Prime Minister who made the recommendation for the minister to have that job in the first place. And that letter of resignation is sent from the Cabinet Office to the Governor General, attached to a letter that is drafted in the Cabinet Office for the Prime Minister's signature, advising the Governor General of the revocation of that minister's job. The Cabinet Office is also responsible for government parliamentary business. The Cabinet Office prepares the document for the Prime Minister to send to the Governor General, dealing with or setting a date to prorogue or dissolve Parliament. The Cabinet Office, on the instructions of the Prime Minister, puts to the Cabinet when Parliament should be summoned, and the Governor General is informed of Cabinet's agreement via Cabinet conclusion. When there is a change of government, when there is an incoming administration, even if an old political party or a former political party is being returned to power, the Cabinet Office is extremely busy. The Cabinet Office is responsible for the preparation of a draft memorandum for the Prime Minister to put to Cabinet to advise the Governor General of the date of the opening of the new Parliament. The Cabinet Office is responsible for advising the Prime Minister of the need for the preparation of the speech from the throne. Now, you may think that this may sound redundant and the Prime Minister should know this. But remember, a Prime Minister, the leader of a party who now becomes head of government, may not have ever been a minister or may have been a minister and not a Prime Minister. So it is important for these matters to be brought to an incoming Prime Minister's attention. And this is the role of the Cabinet Office. Following the allocation of ministerial portfolios, the Cabinet Office also informs the Prime Minister of the postings of permanent secretaries to serve those ministers. So an incoming Prime Minister decides that Mrs. Willoughby Salke is going to become the Minister of Education. She decides that Camille Johnson is going to become the Minister of Works. Mrs. Garraway is going to become the Minister of Health. So while all of those decisions are taking place, the Cabinet Office is fixated on that. And once those positions are firm, then the Cabinet Office backtracks and now advises the Prime Minister who the permanent secretaries are in these ministries who have to work along with the ministers whom he has assigned. The Cabinet Office also informs permanent secretaries at the earliest opportunity of the allocation of portfolios or changes in portfolio allocation. So a permanent secretary who is in the Ministry of Education at the time of following a general election has to be advised of who the incoming minister is, and also has to be advised if the new Prime Minister has decided to remove her and replace her with someone else and the place to where she's going. And that is the role of the Cabinet Office. The Cabinet Office is also responsible for sending a circular to all permanent secretaries requesting inputs for the speech from the throne. As I said earlier, when there is a change of administration or when there is or following a general election, the Cabinet Office is extraordinarily busy. It is a time when all hands are on deck. You don't work from 9 to 5. You work from when you begin and you end when the task is completed. It is the responsibility of the Cabinet Office to coordinate the contributions and the preparation of the draft of the speech from the throne. The speech from the throne is the statement by the Governor General, who is representing the Queen, of the priorities and the mandate of the government for the next 5 years. And this is why the Queen says, my government, or the Governor General says, my government. Because remember, in our system, it is the Governor General representing the Queen who is the head of the government. And in the Constitution, it is the Governor General who delegates executive authority to the Prime Minister to run the country for her. And this is in the tradition of the British system of government, where the Crown no longer rules. The Crown reigns. And this took place in the early 18th century, when two foreigners, William and Mary, came to the throne of Great Britain, and the people in Britain decided they wanted to rule themselves. So we still follow that tradition, where the Queen is the titular head, but the de facto or the actual head is the Prime Minister. And this is why the speech from the throne is prepared in the Prime Minister's ministry, i.e. the Cabinet, which outlines what the government will do for the day. The Cabinet Office is also responsible for ensuring that 2 copies of the approved speech from the throne are bound with ribbon for presentation to the Prime Minister to give to the Governor General at the opening of Parliament. There's a lot of ceremonial activities that take place around the opening of Parliament, and all of this stuff, all of this is done in the Cabinet Office. The Cabinet Office is likewise responsible for ensuring that at the opening of a new Parliament, there is a representative from the Cabinet Office, usually the Cabinet Secretary. Sometimes it's the Chief of Protocol, who have the 2 copies of the speech bound and ready to give to the Prime Minister when he leads the procession from the House of Assembly to the Senate at the opening of Parliament. Before we go on, I want to go back. Before we go on to some of the other functions of the Cabinet Office, I want to pause and ask if you have any questions that you would wish to raise concerning the role of the Cabinet Office once the government or on the opening of Parliament, or a question you would wish to raise on the activities, the external activities of prime ministers and premiers who are in fact the ministers with responsibility for the Cabinet Office. Okay, there being no questions, we could move on to additional responsibilities of the Cabinet Office.
Johnson. Ms. Johnson.
Yes.
I have a question, please.
Go ahead.
My question is, you indicated that the Cabinet is responsible for getting 2 copies of the opening ceremonies and what have you, right? Do any of the copies go to the Queen since she's the head of the Commonwealth or anything like that?
No. The Queen herself is the titular head. Of the many Commonwealth countries, she is not involved in the day-to-day management. That's why she has appointed a Governor General who acts for her.
Okay.
Okay.
Thank you.
Thank you. Thanks for the question. The Hansard.
Yes.
Now, the Cabinet Office is also responsible for the Hansard. In the early days, Parliament in Britain was not interested in having its proceedings made available to the public. But due to the growing weight of public opinion and increasingly outspoken attacks on the Parliament by the press, the Parliament decided that they would make their deliberations available to the press. In 1812, the first publication of parliamentary debates occurred in Great Britain. The parliamentary debates was taken over by an individual named T.C. Hansard, and this is where we get the name Hansard debates. In the Bahamas, not until 1979, when Sir Henry Taylor was made the first editor of Hansard, did we have our first Hansard publication. So it's important to see how it evolved and what was the purpose and how it came into being. And I'm not sure about the age of you individuals, and so if you know exactly who Henry Taylor was, but Henry Taylor was made the first editor of the Hansard in 1979. He was instrumental in the formation of the first political party in the Bahamas, that is the Progressive Liberal Party. What is the Hansard? Hansard is the official record of the proceedings of Parliament. It is an edited verbatim record of what was said in Parliament, and it includes records of votes and written ministerial statements. It contains the speeches made by members of the House of Assembly and senators, their contributions to debates and petitions, the results of votes on bills and motions, and sometimes it even includes the hecklings and the interjections.
I like this.
The Hansard provides a substantially precise account of proceedings of Parliament and its committees. It neither adds to the discussions nor detracts from the meanings of what is said. It is a full report and it is written in the first person. The members' words are used. Clarity is provided, ambiguity and elegant variations are avoided. It is an official record of what was actually said in Parliament when acts were debated, although debates are edited in accordance with parliamentary editing guidelines. Why is Hansard important and what is it used for? It is used to clear up ambiguities in legislation, and it is also used to prevent obscurities in legislation, because legislation is introduced into Parliament by the executive, by the government, and then that legislation is debated in Parliament by the opposition. It is supported by government ministers. If there is any ambiguities or things that are not clear, the Hansard would have an accurate recording of what the questions were, what the issues that were raised. The material relied on comprises one or more statements by a minister or the other persons who are promoting the bill, and such other parliamentary material as is necessary for an understanding of what the ministers or the promoters have said and the effect of what they would have said on the bill. Now, this is an extremely important function of the Hansard. It is also important in limiting the statutory interpretation of laws. Parliaments are unable to make their own judgments on cases. If they stumble, they can rely on the Hansard. It is the responsibility of Parliament to make laws, not to interpret it. That is the function of the judiciary. So the Hansard will contain an accurate record of what was introduced into Parliament, meaning both the House of Assembly and the Senate. And it will also include precisely what was said so that the judiciary in its interpretation is able to see what was the intent of the lawmakers. The Hansard is important because of its use in the principle that when primary legislation is ambiguous, then in certain circumstances, the court may refer to statements made in the House of Assembly or the Senate in an attempt to interpret the meaning of the legislation. The Hansard itself is really written by two groups. Since it is a record of what is said in Parliament, it is actually written by members and senators who speak and who make their contribution. And then it is also written by the reporters who later transcribe them. Hansard used as its sources previous acts of Parliament on the same topic, earlier case laws, dictionaries of the time, and the historical settings. So just to recap, Hansard documents are debates, which are the reports that are transcribed, edited, and corrected of what is said in Parliament, journals, the official record of the decision and other transactions of Parliament, and order papers and notice papers, which contain the listing of all items that may be brought forward on a particular sitting day and notices for upcoming items. So you have sitting in Parliament officers who are transcribing what is taking place, and these officers are Cabinet Office staff. How do you think, just one participant, give me an answer to this. How do you think that we can get better accuracy in the recording of what is said in Parliament in this day, in the 21st century? What do you think would be a useful tool to get better accuracy of what is recording during these parliamentary debates?
Use a recording device rather than you rely on what the person's right.
Yeah. Yes. Are there any millennials in the group? Because can you take that a stage further?
Yes, perhaps we can use devices that write what people say as they speak.
Excellent. We can reuse a voice-to-text recording, because even when you are recording, you still have somebody else transcribing. But
Right.
if in the 21st century you use a voice-to-text recording, as you speak, the document, the device automatically transfers it or puts it into text. So there are things that can be done to improve the efficiency of the Hansard process. So in addition to producing the records of parliamentary proceedings, Hansard provides transcripts and broadcasting services to parliamentary committees. And Hansard is responsible for broadcasting the proceedings of both houses of Parliament via the parliamentary channels. You know, this is a newbie, and recording wasn't allowed in the House of Assembly and in the Senate until Prime Minister Ingram liberated the airwaves. So you have masses of people home in the Bahamas who can see and hear in real time what is taking place in Parliament. And this is really good for those persons who are retired. And I also want to point out too, that in this country, we have an extraordinarily high number of people who are engaged in our political process. And so having access to what is happening in Parliament is a way to provide them with information directly without them having to depend upon reports from the media, often skewed, and also including their opinion. So the Hansard and the parliamentary channel is a very, very important tool. In the Bahamas, transcripts are provided upon minister's request, but they are not available daily. In the UK, Hansard is available on the internet 4 hours after the House adjourned for the day. And weekly Hansard, which comprises the revised dailies for the week, is available on the internet 3 working days after the end of the sitting week, and in hard copy approximately 1 week afterwards. The books are later incorporated into bound sessional volumes. So we still have a lot to do to get to that. And as you people move up in the ranks of the public service, some of you who will eventually reach the cabinet office, this is the goal to which you can aspire. Here is another picture of the cabinet of the Bahamas in 1967. And I'm sufficiently old and proud that I think I need to call out the names of some of these people for you, because some of these you may think are just names that belong on the building. In the background is Cecil Wallace Whitfield. Next to him is Milo Butler, who was the first governor of the Bahamian governor of the Bahamas. Next to him is Arthur Hanna. Then this is Clarence Bain. Next to him is Jeffrey Thompson. Then this is Carlton Francis. This is Randall Fox. That's Warren Lavarty. This is Curtis Macmillan, and this is Clement Maynard. And of historical interest, this is the 67. So he was premier. This is Premier Pindling, and he is here with the British governor, Sir Ralph Grey. So we have not yet had our first Bahamian governor, and this is still a colonial governor. I thought this picture was of interest because of that. Now, the Cabinet Office is a ministry. So the Cabinet Office as a ministry is headed by the equivalent of a permanent secretary. In our system, we call that individual the secretary to the Cabinet. And I wanted to pay homage to persons who have served as secretaries to the Cabinet from the majority rule time. Here we have Mr. Rodney Bain, who was the first secretary to the Cabinet on majority rule. And even way back then, the Bahamas paid attention to and recognized the contribution of females, because Mrs. Margaret MacDonald was made Cabinet Secretary. She was followed by Mr. Basil O'Brien, and then Mrs. Anita Bernard, followed by Mr. Wendell Major, and then followed by me, Camille Johnson. Here is a list of the dates and the times of the secretaries to the Cabinet. Again, of historical interest, you will see that when we achieved majority rule in 1967-68, we had a British secretary to the Cabinet, Sir Alfred Foley Francis Polden Newns, KCMG CVO. He was the secretary to the Cabinet during the time of the majority rule. And so he played an integral role in the Bahamas in those early days. The current secretary to the Cabinet is Mrs. Nicole Campbell. In addition, all the functions you learned yesterday about permanent secretary, in addition to being chief advisor to the Prime Minister on government and ministry matters, in addition to coordinating ministries, being the chief financial officer for the Cabinet Office, in addition to being responsible for organizing the work of the Cabinet Office, the Secretary to the Cabinet has specific duties associated with managing the affairs of the administration of the Cabinet and the operation of Cabinet meetings, as the Cabinet Office is the Secretariat of the Cabinet itself. I want to mention at this stage that the Secretary to the Cabinet is also head of the public service, and that is an extremely important and time-consuming role. When I was Secretary to the Cabinet, I spoke to P.S. Bodie and P.S. Delancey at least 5 days a week, and there's 7 days in the week, and those 5 days often included the weekend. So as head of the public service, you do have an active role to play with the public service. Here is a picture of the Cabinet ministers in 2002 in the Cabinet room. You will note that the Prime Minister sits in the center of the table, not at the head. And to his left is the Deputy Prime Minister. Here is a picture of the Cabinet ministers in 2017. And I've included this to show you that the Prime Minister again sits in the middle of the table. To his right is the Secretary to the Cabinet. And to the Prime Minister's left is the Deputy Prime Minister, who was absent that day, which is why the Minister of Tourism slipped into that seat. And next to the Cabinet Secretary is the Attorney General. If you look closely at this picture, and hopefully you're seeing the full picture, my screen has pictures of you on the side, so it's kind of truncated. If you look closely at this, you will see there's a mic in front of every minister except the Cabinet Secretary, and that is deliberate. The Cabinet Secretary, that's not her meeting. The Cabinet Secretary is there to record the deliberations and the discussions of the Cabinet, not to take part in the discussions of the Cabinet. But seated in this position, the Cabinet Secretary is able to remind the Prime Minister without speech by sending a note of matters that may not be addressed during the deliberation of a Cabinet paper. And the Cabinet Secretary also, at least I did, I also would slip notes to the AG when I wanted specific things brought up that were being ignored. But the real point here is that the Cabinet Secretary does not have a mic. Off the picture in the back, there are recorders that sit in the Cabinet room along with the Cabinet Secretary, and these persons are also taking minutes of what's happening in the Cabinet sessions. The Secretary to the Cabinet advises the Prime Minister on the Cabinet papers, on the Cabinet numbers to be given to each minister. Let me explain that. You see ministers driving around with a license plate number 2, 3, 4, 5, and 6. The Prime Minister is primus inter pares. He is number 1. The Deputy Prime Minister is number 2. And you should note that the Deputy Prime Minister is not a constitutional position. That is an honorary position. Number 3 is the Attorney General. The reason for that is because your Constitution says that there shall be a Cabinet of 9, 2 of which shall be the Prime Minister and the Attorney General. So this is how the Attorney General gets to be Cabinet Minister number 3. Now, this is the role of the Cabinet Secretary. The Cabinet Secretary then assigns numbers to each minister. And I worked out how this is done and put together an algorithm so that to guide future Cabinet Secretaries. All substantive ministers take priority over ministers of state. Among the substantive ministers, persons who were ministers in a previous administration, they are given priority. Among the substantive ministers, ministers who are senators, meaning not elected, they are at the bottom of the parcel. So in assigning the Cabinet numbers for ministers, the Cabinet Secretary follows that line up. Then ministers who are substantive ministers in the Senate will follow. And persons who are ministers of state are at the bottom of the barrel. Those ministers' numbers are then submitted to the Prime Minister, and upon his approval, those ministers are then assigned that number. This is all the business and the work of the Cabinet Secretary. So once papers are published for Cabinet ministers, each paper is numbered with that minister's number. And the Cabinet Secretary also advises the Ministry of Finance of the numbers of the Cabinet ministers, and then those numbers appear on the license plates of the ministers. The Cabinet Secretary also reallocates those numbers if the size of Cabinet increases or decreases. If the Cabinet minister resigns, if a new minister is appointed, the Cabinet Secretary then has to go back, look at the allocations, and bring those persons in. If the new minister who is appointed is a member of the House of Assembly and is a substantive minister, then that person moves forward, and everybody after that drops down 1. If the new minister is a minister of state, then that minister of state, being not substantive, goes to the bottom of the line. And this also puts in motion another set of activity, because licenses for cars have to be redone, and it's just a lot of work. The Secretary to the Cabinet takes the Prime Minister's instructions on the agenda and calling of Cabinet meetings. So generally, Cabinet meetings occur on a Tuesday, but the Prime Minister can call a Cabinet meeting any day, any time, any place that he chooses. He can call you up on a Sunday at 1 o'clock and say, I want to meet with Cabinet at 5. Then you have to convene the meeting, contact the Cabinet members. You have to contact your staff. You have to make sure that the microphones have been charged, that there's someone to clean the office afterwards. So that's the responsibility of the cabinet secretary. The cabinet secretary also sets the date for receipt of submissions for consideration on the upcoming cabinet meetings. You learned from yesterday that ministries send matters into cabinet to be considered in the form of what we call cabinet papers. The cabinet secretary advises permanent secretaries when is the deadline for receipt of those cabinet papers. And in our current system, our prime minister spends Thursdays in the cabinet office. So all those papers should be into the cabinet secretary by Wednesday. So he would have an opportunity to vet it, and we'll discuss that later on, and determine whether they are ready to go forward to the prime minister for his review. The cabinet secretary reviews and amends memoranda from permanent secretaries for submission to cabinet and ensures A, appropriate language and tone, B, inclusion of all relevant facts, C, appropriateness of annexes, and D, inclusion of opinions and advice from the Minister of Finance on matters requiring expenditure and the ministry responsible for public service on matters relating to employment. These information needs to be in the cabinet paper. It's not good enough to say the opinion is attached as an annex. That information needs to be in. And it's also not good enough to say that the Minister of Finance will give his contributions at the table, because the Minister of Finance need to have seen that paper to get from his technical people their input and advice on the matter at hand. So it is important for those papers to come in goodly time for the cabinet secretary to check and vet them and make sure that all of this is in fact done. Sometimes when cabinet papers come in, if they're not appropriately in language and tone, they have to be returned. If they do not include the relevant facts, the cabinet secretary has a discussion with the permanent secretary and would say, for example, in considering this matter, why is there no economic analysis? This would be better put to ministers if you were to show what is the historical precedence for such. So a lot of that goes on before a cabinet paper even reaches the prime minister. And this is why the papers come in with the files attached. And as cabinet secretary, you need to go through those files, because believe you me, the prime minister does. And if you have not, he's likely to call you and say to you, Esther C., did you look through this file? Did you see on folio X, Y, and Z? And if you have not done your homework, then you have been judged and found wanting. The Secretary to the Cabinet vets and forwards to the Prime Minister memoranda from ministries for inclusion on the Cabinet agenda, and is responsible for the preparation of agenda once the Prime Minister has decided that those papers can go forward. Sometimes you send something into the Prime Minister and he decides that he does not want to deal with that at the cabinet level, or not this week, and he will not put that in the agenda. And the Cabinet Secretary has a responsibility in sending those matters into the Prime Minister to put her opinion on the matter to the Prime Minister. So the Cabinet Secretary is just not a post office receiving and sending in. You need to read the cabinet paper, have an opinion, bring to the Prime Minister any matter that you think he would wish to know or needs to know, or even sometimes say to him, look at folio so-and-so, which you would have flagged for his information. The Secretary to the Cabinet is informed by a minister in writing, not by phone call, of any submission not on the agenda that he wishes to discuss in the upcoming cabinet meeting. So once the agenda is set, once they receive the agenda on Friday afternoon, if a minister wants to bring something into cabinet on Tuesday, the following Tuesday, he needs to send something to the cabinet secretary in writing, saying what it is he wishes to do and why this is urgent and why it is coming in late. And the cabinet secretary makes all necessary arrangements to ensure that the subject of cabinet memoranda are kept confidential. Continuing, the Secretary to the Cabinet convenes and attends all cabinet meetings to record decisions taken. No cabinet meeting takes place without the Cabinet Secretary being present. Between March of 2020 and December of 2031, all cabinet meetings, I attended all cabinet meetings virtually from my home because I was in isolation. But no cabinet meeting takes place unless the Secretary to the Cabinet is present. And the Cabinet Secretary also provides extracts of cabinet decisions called conclusions to permanent secretaries or heads of department for actions to be taken by relevant ministries. Now, those conclusions are not minutes. The cabinet secretary does not record in minute form what takes place in cabinet. The cabinet secretary sends out conclusions, and these conclusions are action items. If you've ever seen them, it comes back and it says, cabinet considers ICM, whatever the number is, and determine 1, the cabinet A, noted, B, approved, 3, discussed, 4, deferred. There are the action items, and the cabinet secretary has to prepare the conclusions in that format. So when it goes out to permanent secretaries for them to action, they know precisely what it is that they are supposed to do. The secretary to the cabinet also ensures that list of pending legislation is brought up to date, and with the prime minister's concurrence, circulates this list to ministers and permanent secretaries. And the secretary to the cabinet is responsible for maintaining and preserving the records of successive cabinets. Not finished yet. The secretary to the cabinet manages transitions between administrations and supports the continuity of government. The secretary of the cabinet provides advice to the prime minister on central government constitutional, policy, and administrative matters. The prime minister is the head of government. He has the cabinet office as one of his ministries, but he's also involved in everything else. So the prime minister may ask the cabinet secretary for advice on educational matters, matters to do with works, matters to do with the environment, etc., etc., etc. And that is a role the cabinet secretary has to perform. If you do not know, you are to say to the prime minister, I will get back to you on that, sir. And you are to confer with the technical heads, you are to confer with your permanent secretaries, and you are to get back to the prime minister with your opinion based and supported by facts on whatever the subject matter is he has brought to your attention. Now, I have learned that when I got a call from the prime minister at, he knew I was an early bird, 6:30 in the morning, he expected an answer by 9 if I couldn't give it to him then. There's no such thing as overnighting. Get the information, because there is a decision that is contingent upon that. And while the prime minister also has ministers with responsibility for specific matters to whom he would refer for advice, he also wants to feel out the head of the public service and the head of the cabinet office on an opinion based on the totality of the information. And this is generally why the secretary to the cabinet is a most senior public servant. I had 46 years in the public service. And so you have a prime minister who is coming in who may have 15. And so you would have been privy to information, initiatives, things that succeeded, things that failed, things that were put aside, and you are in a position to advise the prime minister on such matters. The secretary to the cabinet conveys collective messages to ministers from the prime minister. So if the prime minister wants something to be sent to his ministers collectively, he doesn't always send it himself. He says, cabinet secretary, please advise my ministers X, Y, and Z. And so ministers come to understand and depend on the cabinet secretary to provide that information from the prime minister. So it is very important. Yesterday, we talked about the relationship between permanent secretaries and ministers. It is very important that the cabinet secretary not only has a clear and visible working relations with the prime minister, but that ministers are also seized on that. And they understand that when the cabinet secretary says to them, something to them, she is speaking with the authority of the prime minister. Let me give you an example. I had occasion to call a minister and say to him, good morning, minister, how are you? Fine, thanks. Yes, cabinet secretary. And I'm saying, how is such and such a matter progressing? And then he says to me, well, we're dealing with it, but it's not ready to go to cabinet yet, etc. And I would say, well, the prime minister wishes to have that discussed on Tuesday. I'll speak to you later. Then I pick up the phone and I call his permanent secretary and I say to him, why is there no cabinet paper on X, Y, and Z? Cabinet, this matter was raised around the table and you have a cabinet conclusion instructing your ministry to come back to cabinet with this particular matter. That was 2 weeks ago. The prime minister wishes to discuss this on Tuesday. When may I expect a paper from you? Now, another name for the public service is the civil service. And it is the civil service because we are extraordinarily civil with one another. When the cabinet secretary says to you, when may I expect a cabinet paper from you after all of that? She is saying, I expect to see that cabinet paper before the end of the day. You know how we write in government. Do circumstances now permit a reply? And we tell you, we have sent this to you twice. Do circumstances now permit a reply? Is public service speak for stop what you are doing, address this matter now, and send me an answer within the next 2 hours. So the same convention applies when you are dealing with ministers. So when the cabinet secretary speaks to a minister, he understands that she is speaking on behalf of the prime minister. The secretary to the cabinet consequently provides advice to ministers when asked on ethical, procedural, or public service protocols, and sometimes also not when asked. If you see that there is a particular position coming forward, or you understand, or you see rumblings that a minister may be holding a certain position, it is your responsibility to head him off at the pass, to call and have a discussion with that particular minister. The cabinet secretary also advises a minister whose appointment has been revoked to return his cabinet memoranda and conclusions to the cabinet office, and informs the treasurer when a minister ceases to be a minister, so that he obviously does not continue to get paid, and also receives car keys, cars, the minister's case, the minister's case keys, and the minister's seal from outgoing ministers. All of these are functions that the cabinet secretary performs. And these are functions associated with the role of the cabinet office as the secretariat to the cabinet office itself. Here is a picture of cabinet meeting in Grand Bahama in January of 2020. I've included this as evidence that cabinet does not necessarily always meet in the capital. I think twice this has happened, maybe 3 times. I think the Christie administration also had a meeting of cabinet. I'm not sure if it was in Abaco or in Grand Bahama, but the other point I wish to make is that when that meeting takes place in Grand Bahama, it is still the cabinet secretary's responsibility to ensure that everything is in order for that meeting. And in such a case, the cabinet secretary will work with the permanent secretary in the Ministry of Grand Bahama to ensure that all takes place. But if anything is awry, it is not the PS in Grand Bahama who is held accountable, it is the secretary to the cabinet. I'm going to just pause there before we discuss the next slide and ask if you have any questions relative to that. And can there be only one? Because there are many other things the cabinet office does. And I'm seeing from the time frame, I want to at least give some kind of parity with the office of the prime minister. One question.
Good afternoon, Ms. Johnson.
Good afternoon.
A matter that is not, or that's not been genderized, can it be orally presented at the table at cabinet?
Absolutely not. You can bring a matter to the cabinet and you can raise it as a discussion item, but it will not be action. If you have a matter that you wish to bring to cabinet and it's not on the agenda, let me find the slide, you call the cabinet secretary, you inform her in writing what that matter is. The cabinet secretary will then provide that information to the prime minister, and the prime minister will determine whether or not that matter is to be handled. It is unwise to bring a matter across the table. Where are the annexes? Ministers have not had time to consider the matter properly. What I didn't say because I was on skates is when the prime minister finishes on Thursday and decides what the agenda is, the cabinet secretary and her staff have 4 hours. Run the agenda, run the cabinet papers on the prescribed cabinet paper form, number them, put them together, package them. So by 1 o'clock, the cabinet messenger is taking those papers to the cabinet ministers for them to look at over the weekend. So when you bring a paper at the table on Tuesday morning, it is the height of discourtesy to your colleagues because they have had no opportunity to review the paper, no opportunity to call you or to discuss even with their own staff how this matter may affect their ministry. So it is discouraged bringing things across the table. Does it happen? Yes, it does. Does it happen successfully? Most of the times, not so.
Thank you.
The Secretary to the Cabinet is also the Secretary of the National Economic Council and the Security Councils. These are two committees, so to speak, of the Cabinet. As Secretary to the National Economic Council, the Secretary to the Cabinet is authorized by Cabinet to sign heads of agreement on behalf of the government. Government ministers do not sign heads of agreement, and secretaries of the Cabinet do not sign heads of agreement because they feel like it. They are authorized by Cabinet so to do. And this is another function of the Secretary of the Cabinet. Here we see Wendell Major, who was the Secretary of the Cabinet, signing a heads of agreement with Mediterranean Shipping Company in early 2019. And to the right, you see Mrs. Anita Bernard, a Secretary to the Cabinet, signing the handover documents from the People's Republic of China through the sports stadium. So these are all functions of the Secretary to the Cabinet. The Cabinet Office also functions as a secretary for the Immigration Board. This is another committee which consists of persons holding office as cabinet ministers. The PM is the chief executive officer of the board, and it is this board which determines the grant of citizenship, permanent residency, and all of that. All of this is work that is performed by the function of the Secretary to the Cabinet. The Cabinet Secretary is at work. Now, here we see Mrs. Anita Bernard. She is seeing Prime Minister Hubert Ingraham off in 2009 as he leaves the country. There are some facets of this job that I didn't find particularly enjoyable, but you do it because that is what you're supposed to do. And here is a picture of me greeting Prime Minister Dr. Hubert Minnis at the LPIA. Now, this was interesting because this Prime Minister developed a habit of having a press conference immediately upon landing. So what I provided with him right here in the corridor on the way as he came in, matters that he needed to be cognizant of before he sat down with the press. So there is utility in meeting the Prime Minister when he comes in or seeing him off as he departs. And that is a function of the Cabinet Secretary. The Cabinet Office is also responsible for government printing. Government printing, I'm going to really move through very quickly with these. Government printing began in Nassau, and in fact, the government printing department was set up and established before majority rule. So a lot of the brochures and the pamphlets and the leaflets that were used during the actual 1973 independence celebration was printed by the government department. The printed material used in ceremonial events are prepared by the government department. Government printing is unique in its functions as a public service entity, fulfilling the printing requirements of the government. Since it began operations in 1968, it has continued to produce exceptional quality work for providing critical support through printed materials for the numerous agencies of the 17 government ministries and their departments. Even though we no longer have government printing producing for us memo sheets, memoranda sheets, letterheads, those things are generally done by the persons who are typing the memo, there is still a viable role for the government printing department. Government printing department has responsibility for the printing of all government acts and statutory instruments and laws, public service stationery, programs for national events and funerals of ranking government officials, annual independence anniversary celebration invitations, program booklets and brochures, speeches from the throne, annual budget communications and budget reports, the official gazette, and many other documents that are used routinely through the public service. Government printing department is a department attached to the Cabinet Office. It will continue to be the responsibility of the government printing department to ensure that the government is able to publish trustworthy documents at the speed and volume required for an efficient democracy in the 21st century. And it is important for the government to have its own printing department because a lot of the documents that the printing department deals with are confidential, and especially the budget. For example, the budget need not be printed before it is produced in Parliament, because if there are changes in taxation, you don't want persons who know that the taxes are going to go up or down to have a run on those items. So unless the secrecy of the government printing department is vital, because if the government's intention to raise or lower a tax is released before presentation in Parliament, then industries can increase imports or reduce imports with that advance notice. The official gazette. The official gazette of the Bahamas was first, well, the official gazette of the Bahamas was first published as far back as 1783. John Wells, one of the loyalists who came over after the American War of Independence, he brought his printing press to the Bahamas and he established a gazette. The Gazette is an official journal of the government in which notices, legal matters, and legislation are published. This is a legal necessity by which official documents come into force and enter the public domain. And you will find that some legislations come into effect on the appointed day, and the appointed day notice is published in the Gazette. So a law may be passed in October of 2019, and then the minister, say on the 15th of October, the minister may decide that the date in which it comes into effect may not be until the 15th of November. And that information is conferred in the Gazette, and it is printed in the Gazette. Section 4 of the Interpretation and General Clauses Act make provision for the official Gazette of the Bahamas. And in this regard, it should be noted that whatever the word Gazette is used in any written law, this can refer to the official Gazette of the Bahamas, any supplementary Gazette, or extraordinary Gazette. The Gazette publishes portfolio allocations, ministers' resignations, transfers, the proclamation from the Governor General on the summoning of Parliament. There are several kinds of Gazette. Sorry, before I say that, I should say to you that the Governor General also can declare by order that certain newspapers are used to contain official Gazette documents. And so far, the Governor General has decided that those are the Tribune, the Nassau Guardian, and the Bahamas Journal. Now, recently, we have started putting things in the Punch as well. And that is because the Punch has a completely different readership from those individuals. So if you want your notices to be seen by all the Bahamas, all peoples in the Bahamas, you need to put them in the newspaper that the people will read. The various kinds of gazettes are the main gazette, which contains general information such as appointments, transfers, promotions, resignations, and retirements of public officers, leave for cabinet ministers, appointment of honorary counsel. So a cabinet minister who's outside of the Bahamas has to get the approval of the Governor General, and someone else is appointed to act in his behalf. That information is also put in the Gazette. The main Gazette also contains applications for both registrations, charter and scheduled flight services, and motor vehicle franchises, probate notices, and other general matters gazetted in accordance with the provisions of the authoritative legislation. The Gazette is prepared and dated every Thursday with 52 issues annually. Should there be any supplementary gazettes, part 1, 2, and 3 to the main Gazette, these are also issued with the same number and date as the main Gazette. The supplementary Gazette, part 1, consists only of acts passed by Parliament. Supplementary Gazette, part 2, consists of statutory instruments which are subsidiary legislations made from existing acts. So if there are amendments to an existing act, that goes into supplementary legislation, part 2. Examples of these are orders, rules, regulations, notices, directions, and bylaws. Supplementary Part 3, this is a trademark journal, contains applications, information on trademarks, copyrights, designs, and patents taken out of the Registrar General's office and submitted only by that department. And the Extraordinary Gazette contains legislations in addition to matters of national interest, which must be brought to the public attention quickly. For example, the exigencies orders that had to be brought very quickly to the attention of Bahamians. These were all published in the these were all published in the Extraordinary Gazette. Government Publication Department is located at Lightburn parking lot on Bay Street. So there's a government publication. This is a misnomer. This should be government publication. In addition to government printing, which is, I think it's on Fire Trail Road. No, Old Trail Road. Government Publications is located at Lightburn parking lot on Bay Street, and it provides gazettes through individual sales or through annual subscriptions. You can also, any member of the public can go there and get a copy of the Gazette, publish a copy of the Gazette, or get an annual subscription. The Cabinet Office is also responsible for national events, planning of national events, and these include opening of Parliament. We've discussed this earlier, Ascension to and demitting office ceremonies by a Governor General, state funerals for governors, generals, and prime ministers, state, official, and state-recognized funerals for cabinet ministers, chief justices, secretaries to the cabinet, and national icons in accordance with existing policies, and independence celebrations. This is also a unit in the Cabinet Office. That brings my discussion on the Cabinet Office to a close. I'm only 8 minutes over time. I'm sorry that we had to rush some of that information. I will pause here to allow a question on national events, a question on government publication, question on the Gazette. Okay. I just want to make a comment to bring this thing real to you. During the pandemic, when we had health protocols, the country was faced with funeral services for a former cabinet minister, and I'm not sure who the other individual was. Now, the cabinet minister who dies out of office is entitled to an official funeral. And the official funeral has all the bells and whistles where representatives of the state, the prime minister, the governor general, these persons are required, not invited. They are required to be in attendance. Representatives of the state includes representatives of the government. And you will recall yesterday, I said the government was comprised of the prime minister, ministers, and public officers whose job it is to implement the policies of government. So permanent secretaries, undersecretaries, and deputy permanent secretaries and directors as senior government officials are required to be present at state functions. Because of the pandemic and because of the reduction in numbers, and also because of the exigency order, there were no funerals to be had in churches. Ceremonies were to be graveside only, and 10 people were allowed to be there. And this created a lot of bad feeling, and in fact, led to a political operative deciding that I was the worst ever cabinet secretary because I refused to approve an official funeral with hundreds of mourners breathing upon each other sitting in Parliament. What we did was an abbreviated version of that and provided all of the other necessities with a recommendation that once the pandemic was over, then the government of the Bahamas would host a memorial service and all the tributes and the speakers could then be had. The offer was rejected. But it is the kind of thing that as cabinet secretary, you have to be mindful of and certainly at all times act in the best interest of the nation. Let us move on then to the office of the Prime Minister.
I have a question.
Yes, go ahead.
My question has to do with state funerals.
Yes.
As you know, we just had the memorial service for His Royal Highness Prince Philip.
Yes.
Yes. Now, in a situation like that, which ministry would take the lead in terms of organizing a funeral? Would it be Cabinet Office, or would that go to Government House?
No, that's Cabinet Office. That's a national service of remembrance. What will happen is the National Affairs Unit in the Cabinet Office will kick in the gear, and they would coordinate with the Secretary to the Governor General. If there are specific matters and specific things that the Governor General wish to be included, then those would be communicated to the National Events Unit, and then they would incorporate those into the service. But all national events are planned in the Cabinet Office by that unit. The Office of the Prime Minister. Prime Ministers have always kept control of the economic development and financial management of the country. This was done from the Cabinet Office, from the physical Cabinet Office in Rawson Square until 1992. In 1992, Prime Minister Hubert Ingraham separated the economic development from governance functions, and he created and established the Office of the Prime Minister as a separate entity and moved the management of those affairs to Cable Beach into Cecil Wallace Whitfield Center. So the matters that are currently being managed and administered by the Office of the Prime Minister prior to 1992 were operated outside of the Cabinet Office. I can imagine the amount of work that previous secretaries to the Cabinet had in managing all of the functions that I've just pointed out to you for the Cabinet Secretary and the running of the Cabinet Ministry, and also the administration of the administration of the Economic Affairs. The first such Office of the Prime Minister shared a building with the Bank of Nova Scotia and the Ministry of Finance. Again, here's a nugget for you, because Prime Ministers also always kept a portfolio of finance. When Bahama conceived its development, it encompassed the land on which the Office of the Prime Minister sat and paid the government to relocate. And so the Office of the Prime Minister was relocated to its current site, and it kept the same name, Cecil Wallace Whitfield Center. The current site also incorporates the Ministry of Finance, again, because it is the usual practice for the Prime Minister to also be the Minister of Finance. So even when he has a Minister of State with responsibility for finance, the substantive minister is still the Prime Minister. So it makes sense for the Ministry of Finance to be in the same building where the Office of the Prime Minister is located. The Office of the Prime Minister is responsible for the following: relations with Clifton Heritage Authority, the Bahamas Investment Authority, promotion, facilitation, and administrative processing of investments, hotel encouragement, National Economic Council, National Development Plan, lands and surveys, acquisition of land, and antiquities. You see why there is necessity for permanent secretaries to work across the board and with each other, because you would have assumed that hotel encouragement might have come under the portfolio of the Ministry of Tourism. Relations with the Clifton Heritage Authority. The Clifton Heritage Authority came into being as a result of an act of Parliament. This act establishes the Clifton Heritage Authority as a body corporate and declares the Clifton Heritage to be an inalienable part of the national patrimony of the Bahamas. That's just fancy language for saying that it belongs to all Bahamians and can't be taken away. The authority shall, among other things, manage, preserve, promote, and develop Clifton Heritage as a national park and historical cultural heritage site, and preserve, construct, manage, and maintain buildings, parks, waterways, nature reserves, and nature trails at Clifton Heritage. That's a lot. So it is very clear that you needed an authority outside of the public service to conduct these functions. But the Office of the Prime Minister is responsible for relations with the Clifton Heritage Authority. So the OPM is not involved in the day-to-day management of the authority. However, the Prime Minister sets policy, guidelines, and representation to Cabinet on behalf of the authority is made through the Office of the Prime Minister, which means that the permanent secretary in the Office of the Prime Minister has to be aware of what is taking place at the Clifton Heritage Authority and needs to establish a relationship with the managing director of the Clifton Heritage Authority so that all times he is aware of what is happening and is able to advise the Prime Minister on all matters related to Clifton Heritage Authority at the drop of a hat. So if the Clifton Heritage Authority requires a policy change or additional funding or anything of that matter, it is the Office of the Prime Minister who has to present that matter to Cabinet on behalf of the Clifton Heritage Authority. A major component of the OPM is the Bahamas Investment Authority, BIA. BIA is the brainchild of Prime Minister Hubert Ingraham. Charged with restoring the country's finances in 1992, he spearheaded a push for the government's proactive economic growth and development by making it easier for international investors to invest in the Bahamas. The Bahamas Investment Authority, BIA, was established to reduce bureaucratic delays for domestic and international investors. I think you're probably here. Okay, I'll follow you. The economic policy of the government of the Commonwealth of the Bahamas, and here it is listed, aims to create a stable society, is grounded in a commitment to building an economic environment in which free enterprise can flourish, where the government assumes its proper role as regulator and facilitator of economic development, and where the ideals of transparency, fair play, and equality of treatment are paramount, and a policy that maintains a stable society in which all people are afforded the opportunity to realize their maximum potential. That's the economic policy of the Bahamas. How does the BIA work? The Bahamas Investment Authority receives proposals and forwards those proposals to relevant agency. It receives feedback on the proposals from the agency so that the investor deals only with the BIA. So an investor who is coming in and wants to put a hotel development, let us say in Meguana, would submit his proposal to the Bahamas Investment Authority. If a component of that proposal includes the generation of electricity, then the BIA sends that to BEC or to the Ministry of Works. If that proposal also includes hotel development, then the BIA would send that to the Ministry of Tourism. Any aspect of that proposal that requires input from any government agency, the BIA is responsible for sending that proposal to the relevant government agency, getting the feedback from that agency, and then the BIA deals with the investor. So the investor does not have to move from agency to agency, dealing with the bureaucracy that can sometimes slow down investment. With regard to especially hotel development and developments of yacht, the BIA will also send those proposals to the Bahamas Investment, to the BEST Commission, now the Department of Environment Protection and Planning, for its input. So all of the inputs coming from government agencies are funneled into the BIA, and the BIA will then interact with the investor. BIA reviews and analyzes proposals and submit these proposals to the National Economic Council and the Investment Board with recommendations for their approval or not. And as we've learned earlier, the National Economic Council is a subcommittee of the Cabinet, and the Cabinet will sit and the BIA will come in, make its presentation, and then the Cabinet, the National Economic Council will make a determination based on those investment proposals. Under Mr. Ingram, way back in 1992, he led 2 investment promotion tours to the Far East and to the Americas. Now, I don't know if you recall, but in 1992, the economy of the Bahamas was on a downslide. So by the Prime Minister himself, as I'd said to you earlier, he is our major diplomat, leading an investment team to the Far East comprised of members from the private sector, members from tourism, and those persons went and sold the Bahamas. They took the national investment policy. They sat and met with counterparts in the Far East. They did the same thing to the Americas, meaning North America and South America. And as a result of that, we saw an increase in investment proposals coming into the Bahamas, because as you know, inward direct investment and the financial services industry is the second pillar of our economy. So all of this was done through the Bahamas Investment Authority, operating out of the office of the Prime Minister. The National Economic Council is headed by the Prime Minister. is comprised of such ministers as the Prime Minister appoints, is responsible for the executive management of the national investment policy, and is the decision-making body for all commercial projects by foreign direct investors. So if you are a Bahamian and you want to have an investment proposal, the only thing that would stop you would be your access to capital. But if you are a foreigner, excuse me, you need the approval of the government of the Bahamas to come in and operate. And that approval is conveyed from the National Economic Council. The National Investment Policy. In 1993, the OPM created a written national investment policy designed to support an investment-friendly climate. This picture you see on the side here is the cover of that initial national investment policy. It guarantees the complementarity of Bahamian and overseas investment, fosters appropriate linkages with all sectors of the economy, in particular, the tourism and financial services sectors, encourages, it is therefore the mandate of the BIA to ensure that all investors in the Bahamas receive the support that is essential for the success of their investment. I was working in OPM at that time as a deputy permanent secretary, and it was a really heady time to work. We did a lot of work, and we had a magnificent team of young people. Shivago Lang was at that time an investment officer who was attached to me, and I was, initially an FAS attached to Barry Malcolm, who was a parliamentary secretary. So my ties and my things with the BIA go a long way back. I was there at the formation of the BIA, and so I know precisely and intimately how it is supposed to function. One of the things that prime ministers do when they come into ministries is introduce new projects, new units to take advantage of or to respond to circumstances that exist at the time. The Minister administration's government accepted and agreed to the recommendation of the Economic Development and Planning Unit in the Office of the Prime Minister to pursue a target-specific, results-oriented performance management methodology in the public sector. And so they created a delivery unit. The delivery unit is tasked with A, finding and providing empirical data for the making of objective and beneficial decisions to spur growth for the Bahamian people in each area of their lives and for the country. B, not just finding it, analyzing the data. C, advancing reforms in top priorities. D, facilitating and providing ongoing support and challenges to ministries and agencies as they keep constant focus on delivery. Next, working on the Over the Hill Rejuvenation Project, the land reform, the energy reform and infrastructure, and the ease of doing business, education, and safety and security. These are responsibilities of the delivery unit, and the delivery unit is headed by Vianna Gardner. This approach has been successfully adopted by governments across continents, including in Latin America and Caribbean countries, where the Inter-American Development Bank has had an active role. Delivery units also exist in Canada, Pakistan, Brunei, Peru, and in the Western Cape province in South Africa. And these units have facilitated the ease of doing business. They have facilitated the ease of doing business. They have been responsible for the delivery of quality water to residents. They have led to reductions in crime. They have led to better qualities of healthcare and education, among others. So this is a new initiative of the Minister's administration in creating and locating in the Office of the Prime Minister the delivery unit. Communications. One of the most challenging factors of not just business, your own professional life as well, is the emergence of social media and the impact of social media on everything we do, how we live, how we do business, how we create, how we communicate. In response to that, a new communication unit was established in OPM in 2018. It is headed by a director who works with the Bahamas Information Service. This unit publishes information about the Prime Minister's activities. The director of the communications unit is responsible for the overall coordination and management of strategic communication within the Office of the Prime Minister, including the coordination of communication for the government on all matters except on matters related to governance. That is the province of the Cabinet Office. Any notification, any closure of a government ministry is not valid unless it comes from the Cabinet Office, and you will recognize it because those notices normally says the Cabinet Office announces for general information that, so on and so forth. But the communications unit is in response to the challenge provided by social media. The mandate of social media seems to be, let me be the first person to get it out. Whether it is accurate or not, we'll talk about that later. And so you find, and this is a situation that governments, regions, businesses across the world, this is not limited to the Bahamas or to the Caribbean region. This is stuff that they are having to deal with. And we have new words coming into the lexicon, like fake news and alternate truths. There is no truth. Some things are abiding. There is only one truth. And your version of the truth does not exist. That is your opinion. And so in response to this, the government found it necessary to create a communications unit to be on top of all of the activities and to be proactive so our citizens could have an alternate source from which to get information. The unit is part of the government's ongoing program to communicate with the Bahamian people through the full range of communications platform and media. The Prime Minister is also responsible for the Department of Lands and Survey, and this is a department that is attached to the Office of the Prime Minister. Crown land. What is Crown land? We hear about Crown land all the time, and sometimes you wonder exactly what is that. Crown land can be defined as public land. It is a territorial area owned by the state or the government to which citizens can have access and right of use. It is estimated that 70% of the land in the Bahamas is either owned by the government of the Bahamas or the government holds a leasehold or licensed interest in the land through multiple agencies. The Prime Minister is the minister responsible for Crown land. And that makes absolute sense because land is the basis of wealth. And so prime ministers historically have always, I think with one rare exception, in around 1989, when Crown lands came under the Ministry of Works and Lands. But other than that, the Crown lands and Department of Crown lands has always been in the portfolio of the Prime Minister. In the Bahamas, Crown land is categorized as, land in the Bahamas is categorized as Crown land, Treasury land, Hotel Corporation land, Ministry of Housing land, Ministry of Education land, agricultural land holdings, including that held by both the Ministry of Agriculture and BAIC, National Insurance Board land, reserve land, for example, marine protected areas, including that held by the Bahamas Maritime Authority and the Bahamas National Trust, grants, leases, and licenses to the government, Water and Sewage Corporation land, Bahamas Power and Light land, Public Hospitals Authority land, and all other government lands. So when people talk about Crown lands, lands owned by the government, this is the 70% of land that is owned by the government. Crown land is managed by the Department of Lands and Survey. However, successive governments have not addressed an estimated 30,000 plus applications from Bahamians requesting the use of Crown land. This speaks to the weak management and lack of consistent attention to this process, which can hinder Bahamians from doing business and building homes in their own country. A properly managed system would be beneficial to spur economic growth for the Bahamas, especially those persons living on family islands where the cost of doing business is already higher in New Providence, given higher transportation costs and higher costs for utilities, and the cost for shipping supplies. In 2018, the existing government announced that once enacted, the Economic Empowerment Zones Bill of 2018 would help to establish an inventory of Crown lands throughout the Bahamas in a bid to make low-cost housing available. While this appears to be a progressive attempt to address the problems facing Crown land distribution and ownership, it doesn't take away from the fact that Bahamians feel that they have not been a priority when it comes to Crown land reform. Crown land amounts to approximately 70% of all land in the Bahamas, but the ratio in terms of Bahamian versus foreign ownership is unclear. Earlier this year, the Prime Minister announced that family islanders who have been leasing Crown land from the government would be given the properties they are leasing. This would include those who were impacted by the incomplete Bartad project. The failure of this project left many Bahamian families living on large plots of land which they did not own. And ownership of title is essential for economic development. Many farmers cannot get loans from the bank because they are on grants of land that do not belong to them. So this is, again, the Department of Lands and Survey and the distribution of land is something that has plagued successive governments and is a matter that will require attention. The Office of the Prime Minister also has two subsidiary offices in the Family Islands. The Ministry of Grand Bahama is styled Office of the Prime Minister Grand Bahama. Its political head is a Minister of State, and its administrative head is a permanent secretary. The OPM in Grand Bahama provides services to the residents of Grand Bahama and acts as a coordinating agency for all sub-offices located in Grand Bahama. Can you think of some sub-offices that may be located in Grand Bahama?
Education.
Education.
Department
of the,
Sorry?
the Office of the Prime Minister.
Yeah.
Ministry of Public
Local
Works.
government.
Department of
Public Works,
Immigration.
Passport Office.
Immigration,
Tourism.
Social services.
Yeah, Treasury. So all of those agencies who have sub-offices in Grand Bahama, they all come under the aegis of the OPM in Grand Bahama. While they have heads, technical heads, who reports to the heads of Department of New Providence, they are still all coordinated by the Office of the Prime Minister in Grand Bahama. There's also a sub-office of the Prime Minister in Abaco, whose political head is the Parliamentary Secretary and Representative for Central and South Abaco, and its administrative head is a Senior Administrative Officer. At one time, the administrative head of the OPM in Abaco was an undersecretary. I'm not sure right now where is that the person who is in charge of the administrative head down there is a DPS, but it certainly is not an undersecretary. Are there any questions on the OPM in general, any aspect of OPM, whether you want to ask about Clifton Heritage, you want to ask a question about the Bahamas Investment Authority, whether you want to ask a question about the delivery unit, the communications unit, or also the Department of Lands and Survey.
Yeah.
I have a question, Ms. Johnson, but it's slightly different. It has to do with generation property, or generation land. And I was wondering whether or not the government or the Department of Lands and Survey is perhaps maybe looking at, regularizing generation property, because as you know, people who live on those properties, they can't really do anything with them. So I just wondered whether or not we would eventually move in that direction to sort of help those persons out who fall in that predicament.
Okay, that is a legal question. That would not come under the Department of Lands and Survey. That is a matter for the Office of the Attorney General, because generation and property is property that belongs to a generation. It has an owner. It's just that the owner is such a disparate group of people. And so that is a legal question that would have to be determined by the generations and the Office of the Attorney General. That would not come under the Crown Land, the Department of Lands and Survey, unless only if the Department of Lands and Survey is required to identify and do a survey and delineate where the generation property exists. But the actual, I think what you were speaking about is the distribution of generation property to succeeding generations. That's the legal question. That would be outside the ambit of the Department of Lands and Survey.
Thank you for your response.
Okay, Ms. Johnson, question.
Yes.
Grace Lake, Department of Local Government. Going back to the Office of the Prime Minister in Grand Bahama and in Abaco, are you able to say what was the rationale behind having Office of the Prime Minister? Because it seems like a lot of what they're doing in Grand Bahama and Abaco, we have our Family Island Administrators offices on the various family islands doing the same thing. So just wanted to know the rationale behind creating these offices.
Okay. Grand Bahama, in particular, Freeport is the second city of the Bahamas. And the people in Grand Bahama felt that they needed to have special attention paid to their matters. So with that in mind, I think it was in 2012, the Christie administration decided that they would create a ministry specifically to deal with Grand Bahama matters. And of course, once you set a precedent, you know what happens after that. When you look in terms of the economic contribution to the consolidated fund or to the government of the Bahamas, Abaco sends a significant amount of money into the treasury. And so if you go back to that old 1776 cry in the United States, no taxation without representation, those persons are saying, we are putting our money in, we need to have a seat at the table. We would like our own minister to look at all of our issues. And while New Providence and while those ministries are a microcosm of what takes place in Bahama, it satisfies a need for those people. When you talk about Maslow's hierarchy of need, there's something about fulfilling people's expectations. And sometimes you have to do things that may not appear to be marginally, how should I put it, money generating, but that satisfies your soul. You know, the person who decides at 65 that they are going to retire, although they have a lot more in them because they want to do some other things for which they are not going to get paid. Ha 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 ha. You know, this is the same kind of thing that operates on a national scale. So there was a feeling in Grand Bahama that they needed to have a minister attuned to all of and a ministry attuned to all of their sufferings. And I can tell you, during Hurricane Dorian, the Ministry for Grand Bahama functioned superlatively. There was no, at that time, ministry devoted to disaster preparedness. And in any case, we in the capital were far away. And I salute my colleague, Harcourt Rao. And I salute also the Minister of Grand Bahama, Kwesi Thompson. They stayed there and they moved from OPM into another building and they rode the storm out. And they provided leadership by example, by staying there and being there with the individuals. And that kind of thing, you cannot put a price on it. And it is a recognition of the family islands, as significant partners in this archipelago that is the Bahamas. You know, you do know that the other archipelago in this region is called the Lesser Antilles, and they are all individual island states. We opted to stay together as a federation or a commonwealth, and that enabled us to move forward because the sharing of all our resources benefited all of us. And so we also have to share power as well. And this is the rationale behind the creation of those two ministries. We are now into I have some questions for you. Last question.
Johnson, please don't leave it. Deidre Dumont has had her hand up for a while. Please give her a chance.
Deidre, what's saying, girl? Go ahead.
Oh Lord, let me call you back, okay? I'm blind.
I'm sorry, I didn't hear anything.
Ms. Dumont is muted. Her mic is muted.
Sorry. Hi, Ms. Johnson. I wanted to know if you could expand a little further as to what you think land and surveys with respect to Crown land can do organizationally to be more prepared, or with assisting with that, because it has, you said, it has been a long-standing problem. And there have been many applications, but the process seems to be so labored. Is there something, do you think that it's just a matter of management, or is it will, or a bit of both?
I think it's management, which is linked to resources. Surveying, hold on, listen. Surveying is not a glamour profession. And persons who go into surveying, there are so few of them that they make big bucks not working for government. And so you generally find that there may be 2 or 3 surveyors in the Department of Lands and Survey. And any discussion about land begins with identification of where that land is and marking that land out. And we have had 3 people who are surveyors, 2 people who are surveyors, and they work in government and they also work for themselves. You all are real people, you know what I'm talking about.
Yeah.
And so things do not move forward as readily as we can because of the human error, the shortage of human personnel. There are some, we have to do a better job of inculcating in our young people what the opportunities there are and what is needed for national development. And we should be giving scholarships, quite frankly, to people to go and do surveying and bonding them so they come back and they work for us.
Exactly my point. That was going to be my next question. I mean, it's straightforward, right?
Yeah, as long as we do not have the human resource capacity, whatever you come up with ideas, they become visions and they do not become implemented. So I have to turn that back upon millennials and Gen Xers, people in the 40s category, people in the 30s category, to look and see what is the potential for. Lots of people are not doing anything, not because there isn't any work to be done, but because they have decided they don't want to do that, but they're not aware of the opportunities for doing that. And sometimes when you go to schools, they do not put the kind of emphasis on, not so much on STEM, but that too as well, but on these ancillary stuff. Somebody who has a bent for geography may not necessarily be a thespian. That's not someone who's going to sit down and join you in plays. But if they have a skill set, that then devolves upon, I guess what I'm saying in a guided way is that our educational system needs to be expanded to allow for these opportunities to be more visible, for us to create some of these needs. And as I said earlier, land is the basis of wealth. This is where you start. And so that's a very good question. And I'm glad to be able to expand on that. When you go to the back of your, I'm again mindful of the time, I have some discussion questions based on the presentation, because sometimes people say to you, you have any questions? Do you have any questions? And sometimes you can have a better discussion maybe if you provide questions to stimulate thinking. So what do you think? What do you think? There are enough questions here for many of you, each of you, to have an opportunity, so not let everybody answer at the same time. What do you think is the primary?
Ms. Johnson, before you go on, all those persons who've been speaking all morning and all yesterday, they've expounded and elaborated and showed us how much they know. Please give the others a chance to answer.
Thank you very much.
Thank you, ma'am.
So I do not want to hear a voice that I have heard before. And if you have not answered before, this is not only your opportunity to speak, this is your obligation to speak. And one of the things I used to tell my children, quickly pick out which question you are going to ask, because if you don't answer the one, you are going to be asked to answer something that you may not know. This is the easiest one, and this is the first one. What do you think is the primary role of the Cabinet Office?
To facilitate the needs of Cabinet.
I would say that would be a point A under an umbrella clause, but that's a good one. Can I have another answer? What is the primary function of the Cabinet Office?
Is it the Secretariat of the Cabinet?
to provide all of the services to the Prime Minister, the ministers, and to ensure the timely information coming from ministers and directors that are needed so that cabinet can have their discussions.
What is a collective noun that could sum up all of that? Because you can't
To coordinate.
To coordinate.
To coordinate.
Stop right
The
there.
secretariat.
Secretariat of the Cabinet Office itself.
Stop right there. I asked you for a noun and I'm getting a bunch of verbs.
Secretariat.
No.
Coordinate.
Policy?
No.
Organization.
All of those are things the Cabinet Office does, but you could sum up all of them. The Cabinet Office is responsible for
decision making.
No.
Decisions of policy.
Coordinator.
Advising the Prime Minister.
May I give you a hint? What are the only notices that the Communications Office is not entitled to release? Notices related to what? What?
Press release.
Parliamentary
Cabinet papers.
Cabinet conclusion. Cabinet conclusion.
Oh, all right. Let me answer this.
Cabinet is the reservoir of all government decisions are taken.
The primary role of the Cabinet Office is the governance of the country. The governance of the country. That includes all that it does when Parliament is convened. That includes all that happens in the Cabinet room itself. That includes everything to do with government, anything to do with the governance of the country. So the Cabinet Office is responsible for the governance of the country. And the Office of the Prime Minister is responsible for fill in blanks. If the office
Economic development.
Thank you. Economic development. So you have a Prime Minister who is the Minister of the Cabinet Office and the Minister of the Office of the Prime Minister. And both of those offices have equally important but distinctly different functions. So the primary role of the Cabinet Office is to facilitate the governance of the country. And that takes into consideration decisions made by Cabinet, executive decisions, managing the Hansard, all of that stuff. Why is the Cabinet Secretary such an important role?
He's the primary advisor to the Prime Minister.
Her role is important because when governments change, incoming government, there has to be stability to ensure continuity.
Okay, that's a very good point. The Cabinet Secretary is responsible for providing continuity of government. Yeah. And again, that's a catch-all that encompasses everything that the Cabinet Secretary does. And remember, never forget that the Cabinet Secretary is also a permanent secretary with all the functions of permanent secretary, and the Cabinet Secretary is also the head of the public service. So it's being involved in the continuity of government. What is the Cabinet paper?
Cabinet papers, a simple essay, memorandum.
Who among you has written the Cabinet paper?
I have.
I have written the cabinet paper.
Okay, so someone who has not written before. When your ministry sends a cabinet paper, what are they sending forward?
It's a position paper.
Yes.
Seeking a request for cabinet consideration.
A request for something.
Seeking a request for cabinet consideration.
Or information.
Or provide
Seeking approval. A recommendation.
It is a submission to the executive, collective decision on a matter of importance to achieve the mandate of the ministry. That is what a cabinet paper is. It is a submission to the collective executive for a position to advance an item that is part of the mandate of the ministry. What do you think a qualification should be for appointment as cabinet secretary?
Could you say that again?
What do you think the qualification should be for the appointment as cabinet secretary? What qualities, qualifications you think a cabinet secretary should have?
Well-versed in governmental affairs.
Knowledgeable.
At least 25.
Knowledgeable.
Knowledgeable.
Experience in service. Experience in writing.
Flexible, adaptable.
Integrity is the name.
Hardworking.
Leadership abilities.
Okay, stop right there. Stop right there. Let me see if I could summarize what I heard. And I'm putting them not in the order in which you said them, but in the order in which I think they are important. I heard integrity. I heard knowledge. I heard adaptability. I heard experience.
Selfless.
Loyalty. I heard loyalty. There's a biggie that I haven't heard yet.
Confidentiality.
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 Nationalist.
Discipline and hardworking.
Hardworking. Let me tell you something. Let's go back to integrity. You cannot come into this job unless your core is one of integrity. You cannot, you should not. If you are not, don't have your own standards of integrity, stop right now. Do yourself a favor. Say, this is as far as I can go. Because this job requires a great deal of personal integrity. You have to have personal integrity. You have to be confidential. You know, one of the former cabinet secretaries was asked, why is it that you are constantly being made cabinet secretary? And the answer was, because I have been found to be confidential. I know stuff that I will take to my grave. In addition to the public service rule, that matters are to be kept confidential in papers for 30 years, there are some things that you know, that you deep six them as soon as you hear them. Those things may be necessary for you to make a decision, to guide a minister, to move forward, to discuss with permanent secretary. They are never to pass your lips. Some things go in your ear and they're to stay right there. You have to be confidential. You have to be experienced. You have to be flexible. You have to be a leader. You have to be personable. And nobody has said this, but
Available.
you have to be humble. You have to be humble. My friend, you ain't all that in a bag of chips. You just happen to be the person at the time who was senior and in whom the leader of the country reposed trust. During my tenure as secretary to the cabinet, I can think of at least 4 other people who had the chops to be cabinet secretary. So don't come in with no inflated opinion. As in most things, serendipity. I can't break that down right now. I'm on a roll. Serendipity plays a role in where you end up, meaning loosely being in the right place at the right time. But you also should not take this job unless you have personal integrity, and you must be very secure in yourself. You are the secretary to the cabinet. You are not threatened by a permanent secretary. You are not threatened by a minister. You are already top of the heap. The only person who could fire you is the prime minister. And if you behave in a manner that you deserve to be fired, you should be walking before he actually fires you. So these are some of the qualifications of going back again to integrity, because my friends, you are going to be tested. And if your core is not solid, then you are going to crumble. Why does the cabinet secretary not normally travel with the prime minister?
She has said why.
It's for safety purposes.
Be the next person to advise.
Yes.
Continuity.
There's a plane crash.
On his
We
return,
can't
she
have
has
two
advised
programs
us.
at a time. Okay, crash.
What's going on in the country.
I think there's so much noise. I think I may be hearing the answer. First of all, we're not royals. We don't have to travel on separate planes like the royal family, you know, where Charles goes on one plane and William on the next and George have to fly on another plane. The line of succession is not hereditary and automatic like that. In one day and out the next. What did I say? There are 4 other people I could think of who could have done my job while I was there. So if something happens to me, they could step up to the plate. But the cabinet, somebody has to use a colloquialism, mind the shop.
Stay home
Yeah.
and be
Stop
aware.
trying to talk
Yes.
when the prime minister is there. And also too, this is why unless it's a specific state function, you don't see the cabinet secretary pressing herself up every time the prime minister is speaking. What? You have stuff to do back of the house while he is there, while he's out doing what he's doing. Your job is done when you safely see him out and he's gone to his function. He has all the material that he requires. Now you need to move on and use that time to do something else. And that involves domestic travel. That involves showing up to openings and cutting ribbons and all the rest of that stuff. Having listened to what the cabinet secretary is supposed to do, I thought somebody was going to say to me, well, boy, she can't move. He can't move. He got too much to do. So this is not a job. I know a colleague of mine who was not cabinet secretary, who would have made an excellent cabinet secretary, and who traveled constantly with the prime minister, and she never got to see any place. It sounds so exotic. Oh, you went to South Africa. Oh, you went to Brazil. Oh, you went to this place and that place. You went there. He went. You busy writing speeches, amending things, researching, and doing all the rest of that. So this is not a glamour job. If you want to see the world, go and be a stewardess. Why should the government continue to have a printing department?
So that they can print their own documents for confidentiality.
Confidentiality.
Accurate information.
Yes.
Confidentiality.
For accuracy.
Confidentiality.
And also
avoid fake news.
And also fake news, and also what I term loosely as control. But those persons in government printing department, shout out to Stefan Collins. They will work until 3 o'clock in the morning to get something out. And sometimes because of the nature of government, this is not a matter of bad planning. This is a matter of time factor. We cannot control when someone dies. And so an official funeral, when the family produces the booklet for you on Wednesday and the funeral is on Friday, they come to you with all of those pictures, has to be done. During the demission and commissioning ceremony of the former governors general, they worked long hours to make sure that the programs were presented. We were in one function and the programs were being printed for another function. And then sometimes sometimes again, as cabinet secretary, I don't want the prime minister signing anything unless I proofread it. Because sometimes things go awry. And sometimes you put things in the system. If you've ever dealt with a computer and you make corrections and then you send something out and you wonder, well, what happened? I corrected that. And you might have saved it. Sometimes things happen and you didn't save it. So sometimes fresh eyes are good eyes. So you need to have your own printing department so you could control the accuracy of the information, the confidentiality of the information, and also there need to be a source that the public trust to receive and get all of these legislations and exigencies orders. Could you imagine these exigencies orders that we were having that were coming out like every other day if they were going to a particular a private sector printing publication? So for those reasons, we are always going to need a printing department, even although you can put your own press and do your own stationery, and also too for uniformity.
Actual reason.
And also for uniformity, because sometimes I see things coming out, and I used to go back and I'd say, well, what gave you the authority to decide that your agency could have your own logo? Like, when did you become owner of Bahamas Government Inc.? As far as that's Inc. mean INC. As far as I was concerned, the chairman of the board is the PM. So how you could decide that your unit want to have its own logo? It looks nice, but that's not nationalistic. You go back to your PS and you'll work out something that has the crest and that conforms. So when people see your logo and they see your stationery, they know that it is authentic. Why have a gazette? Why have a gazette?
Because that's a part of
it. It's the official journal of the government. It's the official journal of the government.
Anything you want to know in
decision
government, you go to the Gazette.
Make sure that government's officials' decisions are officially recorded for history.
And also especially to the legal community. Once it is in the Gazette, an official Gazette, they know it is kosher. I know, for example, And again, coming back to the exigencies orders, they were coming out really quickly, and they were being signed, and some of them were being produced and come up on OPM's website. But the older attorneys had contacted me and they said, oh, we ain't dealing with that. That's not legal. Where's the gazetted version? And so until they got the gazetted version with the statutory instrument number and the wording and the listing that they could refer to those in future communications, they paid no attention to that, even although it was the identical thing. Why is the National Events Unit in the Cabinet Office? Why isn't it in the Ministry of Foreign Affairs? They have a protocol section. Why is it there?
To ensure the quality of the event, to make sure that it's up to national standard, and as well as to make sure that whatever resources are given are, it upholds the integrity of the government.
Cabinet Office is responsible for the overall and the overseeing of basically the laws and orders of the country. And so national events should come under the Cabinet Office, since it's based on, the country, events, the official events of the country.
Okay,
if I may,
go on, Maxine.
Okay, I wanted to say that the Prime Minister is the head of government. And so because the Prime Minister is head of government, it makes sense that when you have to deal with national events, that would come on the Cabinet Office.
Also, there is this thing about, how we say justice not only has to be done, it has to be seen to be done.
Yes.
The organs of the state must be seen to be visible, upholding the, sometimes we regard as ceremonial events. These are the things that appeal to the psyche of individuals. I remember, I'm old enough to remember, I was in the government high school when I think majority rule. And I was still in university when we had independence. And the old timers, when you see Lyndon Pindling, he wasn't Sir Lyndon then. When you see Lyndon Pindling got up and he started to address people in the public service way, you know how we begin. Right Honorable Prime Minister, Honorable Deputy Prime Minister, Madam Speaker, and he goes down the list, all of them. All those old people who didn't think they were ever going to see Black people in the majority. You see the pride swelling within himself. And he was a master politician. He did that every time. That was good for a couple hundred votes. And so you have these things that appeal to our nature as people and that make us feel good. And so I'm really making a determined pitch at your level. As you rise up, it is a responsibility and a privilege to represent the state and to come out to these state functions and to indicate a strength of unity. So national events should be in the office of the Prime Minister because it is an integral part of this governance that we talk about. You must not only be a government, you must be seen to be a government. And when we recognize persons who have died and who gave long service to the country, when we recognize Independence Day, we want our organs of state to be adequately represented, not just the military. We want a good, strong showing of that third group that is part of government, and that is the senior public office. Why is it necessary to coordinate ministries and departments?
They proper
Because they have different goals, and they depend on each other.
So to make sure that efforts
So
are not
the
duplicated.
functions do not overlap.
Right. And
So
overlap.
that they make sense.
Okay,
They have different goals, and they depend on each other.
I'm kind of hearing that.
Information.
I'm kind of hearing it. I mean, you're not as crisp in the framing as I would like, but I think you're on the right track. When you coordinate government ministries and departments, you allow yourself to access talents that may not, and resources that may not be necessary in that may not be found in your ministry, number one. And then number two, you avoid redundancies. So notwithstanding portfolio allocations, and you try to make them as separate as possible, there are groups of matters that are going to overlap. The Ministry of Sports, for example, the Ministry of Sports may not have responsibility for regattas. That may be in the Ministry of Agriculture. But regatta is, Camille Johnson's private opinion, should be the national sport of the Bahamas. And if it becomes that, then it's a sporting matter, but it's a sailing event. So it's also an agricultural matter. So when you are dealing with regattas, it behoves the ministries responsible for marine resources and youth and sports to work together. So when you coordinate, you bring together all the available talent that you have, and you also avoid redundancies. Why did the Prime Minister think it is necessary? Listen to this question before you jump into the answer. Why did the Prime Minister think it is necessary to have a National Economic Council? Now I scared you.
Is it because at the time when it was established, the country was in a free fall, and I think that was one of the way Ingram decided to ignite the economy.
No. National, not national investment, not the BIA. National Economic Council. This is a subcommittee of the cabinet. Why did the Prime Minister think it necessary to have a National Economic Council?
Yes, to go
access to advice from professionals in the field. So they can have access to advice from
to have
economic
first-hand
professionals in the field.
decision-making as relates to national economic development for the country.
Is it someone to make decisions relative to direct investment?
I think I heard it. Let me ask this another way. Let me start you thinking in the right way. What is the profession of Sir Lyndon Pinling?
Lawyer.
What is the profession of Right Honorable Hubert Ingram?
To review.
Okay.
To ensure that he get the best advice from persons in that industry.
Right. The reason for the council is so that they all could speak, get an opinion, and be able to meet out the merits of the program.
Historically, our prime ministers have been lawyers, and that is a very good thing, because government is concerned to a very large extent, especially in Parliament, with the making of laws, because Parliament is the legislative branch of government. But by putting together a council, a National Economic Council comprised of ministers with disparate and different backgrounds, he avails himself of advice and skill sets, are not, does not reside in him. I guess the other way to put it is, you don't know everything that you yourself do not know everything. And having sat with the National Economic Councils, I sat with the National Economic Councils under Mr. Ingram, and then I sat with National Economic Councils as secretaries of the cabinet. Individual ministers bring different outlook.
Varying opinions,
They bring different positions also on matters.
You have
varying issues.
You have businessmen, you have doctors, you have insurance executives,
diversity.
You have the diversity. And this is National Economic Council considers proposals that span the entire gamut of economic development. So at one point in time, you will hear one minister take the floor. And then when we come to another project, another minister takes the floor. When I say takes the floor, I mean takes charge of the discussion and is asking questions from the Bahamas Investment Authority. And of course, you're always going to have the Attorney General's office, because there's always legal matters, and you're always going to have the Minister of Finance, because you need to make sure that these individuals who are coming in have been properly vetted and have the funds. So by opening it to a council, the Prime Minister avails himself at the highest level, at the highest political level of advice from his colleagues.
The experts.
Officer, these are now the questions on the Office of the Prime Minister, that's general. Why was the OPM formed? Hold a minute, 1 minute, please. Sorry, Mrs. Garraway. Are we hearing the voices of the people who have not been normally involved in the discussions? All right, let's move on. She stepped out for a bit. Why was the OPM formed?
I know.
Focus on economic matters.
To separate the
Define and
economic
provide
financial
data
matters from the
for
cabinet
making
office.
objective
To separate government
economic
from
development of the country.
the
Economic
cabinet.
and social
Our
goods
Office of the Prime Minister was formed to release some the cabinet office from some of its responsibilities.
Yes, I think it's really becoming a long stretch for Mr. Walker-In. Cleve Walker-In, H.C. Walker-In was the Secretary to the Cabinet when OPM was formed. At that time, I went to the OPM as a geologist / FAS, and there's enough work to go around for both agencies, and so separating them was a good thing. And then, of course, having separated them, then Prime Minister Ingram went ahead to create the Bahamas Investment Authority. Why is the BIA important?
It's simple. It allows the investors just to have one spot to involve their activities.
Minimize the bureaucracy for the foreign investors.
Investors only have to go to one agency.
Yes, and yes.
One-stop shop.
Yes, it is
One-stop shop.
One-stop shop.
Faster turnaround time for delivery of services.
Yes.
No bureaucracy.
It reduces the bureaucracy through which investors have to wade. Why is it necessary for the Clifton Heritage to be under the OPM?
For the long-term patrimony of the Bahamian people.
You turned my words right back at me. Yeah, it is because the matters that Clifton Heritage deal with belong to all of us. It belongs to Bahamians now, Bahamians in the future. And so it needs to be under the Prime Minister, under a central ministry. What is the role of the Department of Lands and Surveys, and why is it in the Prime Minister's portfolio? Let's start with the first part. Why is it in the Prime Minister's portfolio?
Because land is a national asset of the nation.
Public land. The Prime Minister owns
land belongs to the crown, and the crown comes
The government finances the land represents wealth, and so the Prime Minister.
If I was sitting at my piano, I would play some music so you could at the same time. But since I'm at the keyboard, we cannot all hear. Both of our ears work together. So we will only be hearing one of you. So only one person should speak. And be courteous. If you have been dominating the discussion, let somebody else speak.
Yeah. The
Prime Minister is responsible for Crown land.
But why?
Crown land belongs to the people.
Economic resort.
It is the land of the state.
Because 70% of the land is owned by the government.
Land represents wealth. So
That's the answer. That's the answer right there. Not represents wealth.
Land is wealth.
It is wealth.
It is wealth.
Derives from land. And so the head is fitting that the head of the country would be in charge of the department that is responsible for the land that belongs to the country, to the nation.
Ms. Johnson, could you please repeat that again for me?
The reason why Lands and Survey is in the Prime Minister's portfolio is because land is the basis of wealth. Not in 1973 in the Bahamas, not in 1776 in the United States of America, but from Adam. Land is the basis of wealth. And if you remember how civilizations develop, we started with an agricultural society, then we moved to manufacturing. Now we're in the third, which is services. So land is the basis of wealth. And that's why it has always been, except for that blimp that I told you in 1989, it has always been in the Prime Minister's portfolio.
Thank you.
Why do we have a branch of OPM in Grand Bahama and in the Abacos? I think we probably have discussed this before. I think there was a very good question, and I addressed this when I talked about satisfying the psyche and the needs of the people. That's why it's actually there. Now, interesting. Why isn't there an OPM in the Southern Bahamas?
The people haven't advocated for it to that great extent, but it's coming.
The population.
Yeah. Those islands,
Which island did you
are not
choose?
populated. They're not as
Much economic activity down that side.
The services are not required. The need for that because there's not a populace.
One of the challenges of being in this great archipelago is the need to replicate services and the expense of replicating services. When we were dealing with the COVID-19 and the initial vaccines was the Moderna and the Pfizer, and Moderna at that time was requiring storage in the facility minus 70 degrees centigrade. We had a problem because when we thought about storage in the Family Islands, first of all, we were going to have to build such a facility in New Providence. And then you think about replicating the building of that facility elsewhere. There's a reason why education and health get the lion's share of the budget, because health in particular, 83 clinics in the Family Islands, 10 in Grand Bahama, 10 in New Providence. Each clinic requires the equipment that you see in each of the clinics here. And this is why management and governance of the Bahamas is so expensive. And so the idea of creating an OPM in the Southern Bahamas is additional expense when we do not have at this time the population to justify that. Why was the delivery unit formed?
To address or identify
Social
where the
media
mandates of the
needs.
manifesto were satisfied.
To find and provide data for making objective and beneficial decisions to spur economic and social growth.
It accepted the recommendations of the Economic Development and Planning Unit.
To give focused attention to the delivery of services. I mean, I hate to use delivery in the same sentence again, because but ministries already have permanent secretaries devoted to and departments of government to carrying out the government's mandate. So the delivery unit in the Office of the Prime Minister is a unit that ensures that nothing falls between the cracks, and to keep as primacy projects and initiatives that the Prime Minister wishes to keep in the forefront. What are the difficulties in managing lands for the Department of Lands and Survey?
Lack of
human resources.
Lack of resources.
Lack of human resources.
Lack of knowledge.
Manpower, surveyors.
Manpower.
Not too much surveying.
Significant manpower shortages impede the success in the Department of Lands and Survey. Why was a communications unit formed in 2018?
Prevent false to address the social media
to
needs.
make sure information is
Accurate
disseminated
data.
correctly.
Information, freedom, education.
Yeah, it was a response by the current administration to the realities of social media and the new ways in which information is disseminated. And governments historically have been terrible in communicating to its citizens the things that they do. There are so many projects that are underway in each of your ministries. There are so many initiatives that are taking place in each of your ministries that the general public don't have a clue. I read something today that really I had to get up and pace a couple of times. And my immediate thinking was, why do you put pen to paper and embarrass yourself nationally by writing stupidness to the letters to the editor when you could pick up the phone and call? You know, questions. I think it was something to do with the the vaccines, and why is it we only have 20% of our people to be vaccinated, and why the government ain't trying to source more vaccines, and a whole litany of complaints, and all those answers readily available if you had picked up the phone and spoken to someone in the communications unit or someone in the Ministry of Health. So we have to find ways to get information out to combat this tendency to find fault, or also to combat the tendency of people to seek information or to believe the first thing that they hear. So a central communications unit for the cognoscenti, that's you now. Cognoscenti means those who know. A central communications unit in the Office of the Prime Minister is a facility to which you can refer when you want real-time, accurate information about what is happening in the country. Last question. I don't know if I even want to hear your answers, but I want you to think about this. Would you prefer to work in the cabinet office or in the office of the prime minister? Hold a minute. Give reasons for your answer. Now, I have been an employee in the office of the prime minister from 1992 until 2002. I've been there as geologist, FAS, DPS, US, Consul General for the Bahamas in the Far East, and Permanent Secretary. I've also been in the Cabinet Office at the very top. And I have my preference, which I'm not going to share with you.
Office
But
of the Prime Minister.
Given what you know of the responsibilities and the roles of each of these offices, where would you like to work? Honestly, not just a
Cabinet office.
Where would you like to work?
Cabinet office.
The cabinet
office. Your work sounds so exciting.
Cabinet office.
It depends on the management team.
Yeah.
I will tell you where I like to work. I like to work.
I would say both.
Yeah,
everything
is always
urgent
in cabinet office.
I think cabinet office.
I would work in either. Both. Yeah,
I've had the opportunity of working in the office of the Prime Minister, but after listening to you, Ms. Johnson, I would welcome the opportunity of working at the Cabinet Office to have direct.
Let me just say to you, you would be amazed at the small size of staff in the Cabinet Office that carry out all of these works. We have in the public service, we have units comprised of one person. I was the petroleum unit for years, and there was a unit. And I remember going to the Ministry of Works and Lands when it became responsible for Crown Land. And I saw a sign that said, Petroleum Department. And I thought, one lady, 6 filing cabinets, and a room full of data. That's the unit.
That's the unit.
And in the Cabinet Office, I can think of 2 or 3 people who practically run that gazette and who does a lot of that parliamentary work. It is astonishing the amount of work that committed public officers can turn out when they sit their back to it. And the last thing I want to leave you with, just as I wrap up this session, is I want you to have pride in being a public officer. You are part of the team responsible for the governance of this country. You are an integral part of Bahamas INC, whose CEO is the Prime Minister. Nothing, the private sector gets all the kudos, but the government sets the climate within which they operate. The government sets the regulatory agencies within which they operate. When we started yesterday, I said to you, you often hear people say, when they can fix the road, why they don't improve the schools? The government. It is the government who puts in place the standards and policies upon which the private sector builds. And you are a part of that. And you have your feet on the rung of the ladder that will take you up to the top. One of you sitting in this room could end up cabinet secretary. We don't actually have the red phone the way they did in the United States. Remember the ads when Hillary Clinton was running? And the ad said, when the red phone rings, this is the one connecting the United States to the Kremlin in Russia. Who do you want answering it? And there was a picture of, thank Jesus, Trump and Hillary Clinton. This was a Democrat ad. We don't have the red phone, but we have the equivalent of that. And you are in a position to answer, metaphorically, that red phone. So, what are you going to do? Ladies and gentlemen, that concludes my presentation. It was a wonderful experience sharing my insights and knowledge with you. I want to wish you all the best, not only as you continue with this FAS assessment exercise, but also your career in the public service. And remember, in all things, be humble, be truthful, Carry your and wear your integrity as a shield. Be secure in the knowledge that who you are and what you are, if you've done enough and adequate preparation, is sufficient and right for the task ahead of you. Thank you very much.
Ms.